23. Otherwise, they is for hearing.
23.
23.
Okay. Yes. Recorder also here.
Yes. Funding is hearing for the petition. I'm a respondent. I want to perceive my learned find the revision on the ground that the order which is getting passed by the district is actually not taking itself not meeting a second under the newly enacted Contractual Civil Codes Act 1951. Second is discontinued. That was actually secretary, but somehow it was argued on our behalf that between and the court has continued but there is a second way. Again, this can come in division saying that the appeal was not continued. I checked the law possibly my
that appeal was not maintainable. No. And as such, this revision also goes.
The code means the possible revision to be allowed to the extent that you will have to give the opportunity of filing a revision directly to this court. The order passed by imperfectly.
First appellate court.
Only for that court order. I say that after the motions we are pick up. By court order, my learned also agrees.
Okay. After the motion matters. Yeah, there are only 3.
Yes.
So. 20. Okay. 20 is along with 19 and 21. Yes. So all 19, 20, 21 goes. Why? What difficulty you have? This 2016 appeal revision. Almost 10 years. So next week you can do. Okay. Next week, Tuesday. Wednesday. Okay. Wednesday. Tuesday we will have a division bench. So Wednesday. Okay. On the prayer made by your Mrs. C.D. Thongchi. Okay. MSG. Your name is not there in the.
Yes, I'm not in.
Okay. Her on the prayer made by so-and-so, which is not objected to by the learned APP as well as the other respondents are there, right?
Yes.
Opposite sides, which is not objected to by the opposite side, matter may be listed on Wednesday next. That is on 25th of June.
Much obliged.
Yeah. So I'd like to mention item number 13.
1-3.
It has been listed in the orders. Otherwise, this matter is ready for hearing.
Why it has come up for orders? Let us see and pass order.
It has been wrongly listed in 1-3.
Wrong.
13.
13 is wrongly listed in orders.
Hearing.
Achha.
So I have taken consent from my other party also. So it may be taken up next week or after vacation also in the hearing for hearing.
Okay. Heard Mr. So-and-so. And you have informed the other party?
Yes, other party.
You are for petitioner?
I'm for the, yes.
It is stated by Mr. S. Stepin.
No.
S. Stepin that the matter has been wrongly listed in the order column. Full stop. He states that the matter to be taken up for hearing and be listed in the hearing column. As such, the matter to be listed after 3 weeks.
Lost.
And to be taken up for hearing.
No.
Well, I'd like to mention item 14.
I will say. What happened?
My lord, today we are supposed to frame the issues, my lord, but unfortunately, my lord, the file is with my associate counsel, my lord. I don't have the file, so.
File is with
yes, the brief is somewhere.
Okay.
Immediately after the break.
After the vacation?
Vacation.
On the prayer made by Pada.
My lord.
Mr. O. Pada appearing for the respondent, you have informed the petitioner?
Yes.
Appellant, yes. On the prayer made by so-and-so, that the prayer is or not on. The prayer is made by Mr. O. Pada, appearing for respondent, that the brief was mistakenly left with one of his colleague,
My lord.
and as such he could not go through and prepare the same. He therefore prays for an adjournment, list the matter after 3
My
weeks.
lord, can it be on 28th
List the matter on 28th of July,
July, my lord?
2025.
Offline.
May I please, my lord? I beg to mention an unlisted anticipatory bail as last item for today.
Today? Why today?
My lord, this matter is also, yesterday also, it was taken up. The order has been passed, so it's a small matter, man.
Yesterday it was taken up.
From the same
The co-accused.
case number.
Co-accused had moved.
Yes. Small
Then
matter.
what happened to that matter? It is
Interim
fixed.
was granted yesterday.
What is the matter about? I'll remember, let me hear.
That the case arising out of extramarital affair where one of
4 ladies and.
yes, my lord.
identified.
Yes, my lord.
You are for again one of them.
My name is not there in the FIR, but I'm apprehending arrest because I was a witness to that event.
So you are amongst those unidentified persons.
Maybe.
Why are you apprehending?
I was there in the place of occurrence.
With the other accused person?
Yes.
In the same vehicle
Yes.
where they were coming?
Yes.
You can move it tomorrow, get it listed tomorrow. There's no urgency, they will not go and arrest you. And your name is also not there in the.
I'm possible as last item for today.
I list it tomorrow, it's okay. List it tomorrow.
Moreover, I'm in the job. I'm a nursing officer.
No issues, not a very urgent matter.
But last item, if possible, for today.
We'll take it tomorrow in the motion. Okay? I'll list it tomorrow. One way, they will not make any difference. They will not go and arrest. Okay? Tomorrow.
Obliged, ma'am.
May I please, my lord? My lord, I'd like to mention item number 16, my lord. Item 16.
1-6.
Yes, my lord. My lord, this matter will be fixed on 22nd July, my lord. As my,
Orders. Let us
yes.
see why it has come up.
my lord, this matter is appeared by one of my colleagues who is coming from Guwahati. So, Mr. Akram Hussain. So, he requested me to adjourn the matter today.
Today only some order will be passed. No effective order, I don't think so.
All right.
So let it come up.
All right.
Okay. If it is required, we'll get it adjourned.
Yes, sir.
May I, Lordship? I beg to mention item number 22.
22.
And I'm appearing on behalf of our Sonal.
This is a 22 appeal. 3 years have gone by.
Yes, Lordship.
Could have done it. What happened to Rajesh Sonar?
He is engaged in other course, Lordship.
If
So-
this is a
so-
hearing matter, this will reach in the end of the day.
Even in court one also, there's a matter, 2 matters.
Let us wait. If he does not come, okay, fine. Then we will adjourn it.
We have already taken the consent from the other side also.
No, it's okay. But then let us do this matter. What is the bar? I mean, this is an appeal lying there for 3 years. We'll do it next on today's what, Thursday. You'll do it on Tuesday.
No, Lordship, after vacation. Lordship.
Okay. On the prayer made by Miss
Ambassador.
Ambassador. You're for the petitioner, right?
Yes.
Appearing for Mr. R. Sonar, appearing on behalf of Mr. R. Sonar. List the matter after the vacation, after 3 weeks, on a date to be fixed by the registry.
I'm for the state Lordship.
Mhm.
I'm for the state.
And she is there, Lakshmi Hage for the state.
I would like to.
Much obliged.
Your Honor, I'd like to mention item number 4. I, on behalf of respondent Subu Koyang, that due to health issue, the Jing Council is out of station. So may I adjourn for today, and matter may be fixed after 2 weeks, Your Honor.
As prayed for by Mr. So-and-so, you're for the respondent.
Yes,
Your
Your Honor.
Lordship, interim order is there.
Is it a matrimonial issue or something?
No, it's
Maintenance?
for quashing of criminal petition.
Washing of criminal petition and you have not arranged state as a party.
No. I've been instructed.
Because you have to, if it is against FIR, then state has to be a party. But it seems it is between private parties.
Yes.
So I thought perhaps it's a maintenance matter of. Okay, on the prayer made by so appearing for respondent number 2, which is not objected to by the council appearing for the petitioner, list this matter after 2 weeks, after the
Yes.
vacation,
Yes, Your Honor.
after 3 weeks.
Interim will continue.
Interim passed earlier shall continue till the next date.
Oblige.
Your Lordship, I beg to mention item number 6. I'm appearing on behalf of J. Jongluju for all the petitioners.
Oh, he is again out of station, as you have said there.
Yes, Your Lordship.
It is spread on behalf of in behalf of the petitioner that the conducting council is out of station, and as such a prayer is made that the matter be taken up after 2 weeks.
Puja vacation.
Not puja,
Yes.
yes, after the vacation. Listed. Todd, do you need a date or you don't want?
Yes,
After the puja, after
after
the
vacation.
the vacation, on a date to be fixed by the registry.
Oblige, Your Lord.
May I please, Lordship? Lordship, I beg to mention item number 18, Lordship.
Item number 8.
18, Lordship, 18.
18.
Lordship. Lordship, here we are about to file a separate affidavit for the petition, Lordship, and we are having some difficulty in communication, Lordship. So this matter will be listed after vacation, Lordship.
Why you are in a hurry? You want to go? Let the matter be reached. We can see the file and pass the order. It is order matter.
Where are you, Lordship? Your Lordship, this is a joint petition for
For
quashing of.
settlement.
Yes, Your Lordship. Dear case number 130 of 2023, Your Lordship.
What is the offense about?
Offense is a theft, 380.
Theft.
Only 380. Punishment for theft.
Show me the FIR.
Yes, FIR is in page number
Okay.
17.
Trial is on or what?
Yes, it's in CC's place now. It speaks for CC on the 4th of August. Yes.
Consideration of charge.
Yes.
Cognizance is taken.
No, appearance was done, then
No,
yes, cognizance is taken.
Only
Yes.
after cognizance. Where is the FIR?
FIR is page number 17.
Affidavits are filed by both.
Yes, actually the petitioner number 1, the complainant herein is the father, and the victim and the alleged accused is the son. Actually, he was into some kind of alcohol intoxication and was making some family problem. Moreover, here the theft item which has been seized is a brush metal. We call it Adam, a traditional brush metal used in our traditional customary practice, Your Lordship. So only that
Is he an addict or something?
Yes, actually he's an alcohol addict. Now he's admitted at rehab center. Now he's at
That
rehab.
is why he has the habit of stealing.
Yes, actually the
Place the FIR first.
FIR.
Page 17.
Yes, I beg to inform you that on 3rd December 2022 at around 15 hours, my son Sri Tumken Potom, as a 21 years, has stolen away my valuable local antique item from my room by breaking the lock of the room. It was known from Miss Renu Vora, a care of Dr. Soyum Potom of Darak. The actual cost of stolen item was 15,000. He is a habitual thief. Previously, he had stolen away one motorcycle and 10 notes of mobiles from my house and sold the same to someone. And he also attempted to steal my rice mill. He's a drug addicted person whom 6 times kept in the rehab for his treatment but could not make him normal. Therefore, you are requested to take stern action against my son by registering the case and my stolen item may be recovered.
The charge sheet?
Charge sheet is in page number 20, annexure 2.
Relevant part is 23, I think.
Yes, relevant part is 23. May I read you also?
No, not required.
Not
It is also under 380, right?
Yes, only 80. And
These are 161 statements.
yes, 161 statement.
Where is the settlement?
Settlement is phase 47, annexure 3A.
By Luktum, he is the informant.
Yes, he is the
And
informant.
Tumken Potom is the accused.
Yes, Your Lordship.
Okay. What
And
do you say, Ms. Dinik? And what?
And phase number 46 is the admission receipt that he's admitted at Seren Rehabilitation Center, Nahaldaga. Now, since this child, the alleged accused was 21 years old, now he's trying to leave all those bad habits, and he has admitted that henceforth he will start a good life, and he has been admitted, Your Lordship. So, taking this on
These
view.
kind of promises and vows are made by all the addicts.
Yes, absolutely true.
What
But
do you
however,
say, Mr. Ginny?
Your Lordship, I don't have, since they are father and sons, Your Lordship, I don't have any objection. Only with regard to, since the FIR is of 2022, the charge sheet was also filed. So just to ascertain at what stage is the matter before because there is no affirmation made in the petition, Your Lordship.
But he is saying that it is in the stage of
yes,
C.
yes.
It's not
Not a pleaded case. He has not stated anywhere.
Yes, I have not stated. However, I have confirmed, Your Lordship, it's on 4th of August for CC stage, consideration of charges.
4th of August.
Yes,
It is fixed for charge payment.
yes.
Okay.
Till then, Your Lordship, this matter may be stayed. Meanwhile,
Why
record
stay?
that their case, because Your Lordship, he's,
We can dispose of the petition. Why stay?
yes,
Right.
yeah.
There's no point keeping it pending because stated that on 4th of August it is there, and
Yes.
whatever subsequent
that can be
Proceedings.
recorded as per his submission, Your Lordship.
Submission.
I don't have any objection if this matter is.
because it's in drug alley they used to steal. Heard Mr.
Rakshak.
R. Rakshak for the petitioner and Ms. T. Gini, the additional public prosecutor. This is a petition filed under section 528 of the BNSS 2023 for quashing and setting aside of the FIR dated 3/12/2022. Filed by the informant, who is petitioner number 1 in the instant petition.
Is the father, the informant.
Don't write that. You write for quashing of the FIR dated so and so. The subsequent charge sheet dated 3/12/2023, as well as the subsequent proceedings pending before the Chief Judicial Magistrate First Class, ALO. The main ground for the quashing of the aforesaid FIR charge sheet and the proceeding is that both the informant as well as the accused person has entered into an agreement by deed of agreement dated there's no date here.
Your Lordship, it's at the last page, 23rd of June 2025.
Dated 23rd of June 2025. Annexed as Annexure 3A in the instant petition. It is further noticed that the present petition is preferred by both the petitioner, by both the informant as well as the accused person, and the same is a joint petition filed for the quashing of the aforesaid order and the FIR. The allegation against the accused person is revealed from the first information report filed by the father of the accused person, wherein the informant stated that his son, who is 21 years of age, is a habitual thief and that he has stolen many articles, including a valuable local antique item, and sells the same to someone and sell the same to others. The informant also stated that his son is a drug-addicted person who was kept in the rehab for 6 months for his treatment, but he could not recover from the said addiction. The FIR was, the police on receipt of the FIR registered the case under section 380 IPC. On completion of the investigation, the police submitted charge sheet on 14/10/2023 and submitted the same before the learned court of Chief Judicial Magistrate Alo in the state of Arunachal Pradesh. Mr. R. Raksha for the petitioner states before this court that the FIR was lodged by the father of the accused person, who is his son, and the same was lodged before the police station as the father had no alternative. As his son had become a habitual thief and could not be habitual thief and did not recover from his being a drug addict. Although he was kept in the rehab 6 numbers of times. He had placed the deed of agreement between the father and the son, wherein the son had admitted that he had sold the articles No, just cut it. What did I say? Mutual affidavit. Wherein the father had stated that he had to lodge the FIR only to put his son into some fear and pressurize him to stop from excessive alcohol consumption, as his son was addicted beyond controllable limit. And that his son, under intoxication, under intoxication, creates tension in the family members. And being infuriated by the behavior of his son, the father lodged the FIR. On the other hand, Ms. Ginny, the learned additional public prosecutor, states that the FIR was lodged in the year 2022, and she is not aware as to the stage of the proceeding before the learned CJM Allo. However, in her usual fairness, she had submitted that since the incident is between the son and the father, and the son is admittedly an addict, she has no objection if the case is quashed. Full stop. She also stated that continuation of the case would not result in any good consequences, and in view of the deed of settlement, if the son recovers, as it was stated therein, that he will not continue his bad habit, what did I start with? She also stated. Then, okay, full stop. I have heard the parties and have gone through the records. The incident relates to, the incident has resulted due to a very unpleasant situation in a household. A father had to lodge an FIR against his son. Full stop. The contents of the FIR shows that the father had tried to treat his son in the best possible manner, but being unable to do the same, he had to lodge the FIR. He stated in the FIR that his son is a habitual thief and he had stolen many articles and sells it to someone only due to the addiction. In the deed of settlement between the informant, that is the father, and the accused person, that is the son, it is stated in clear terms that father had no other option but to lodge the ejahar, and his only intention while lodging the same was that his son understands and stops the bad habit of consuming alcohol and drugs. The father in the affidavit had stated that the articles that his son sold were his son's articles only. Since he is the only son, since he is his only son. It was further agreed by the son it is further agreed. It is further stated in the deed of agreement that the accused person, that is the son, is in the rehabilitation center and is doing good, and there is every chance that he would restart his life without any intoxication. As it is held in a number of decisions by the apex court, which Gyan Singh versus so-and-so, reported in so-and-so, you already have, you can give that. Ahir Bhai, Parvat Bhai Ahir versus, so those decisions, that only in cases where severe offenses are revealed, such as murder, rape, dacoity, the court should not quash the affidavit, the cases on settlement. But in cases which involves personal issues, commercial transactions of civil nature, matrimonial issues, the same can be quashed by the High Court on facts and circumstances of the said case. Since the present case is between the father and the son is an addicted person, and father has made many endeavors to cure his son from the addiction, and living with no other alternative, he had to lodge the ejahar. This court in the present facts and circumstances quashes the FIR dated 3/12/2022, comma, the charge sheet dated 14/10/2023, and the subsequent proceedings before the Court of Learned CJM, Alo. It is also stated by Mr. R. Rakshap that at present, the case is fixed for consideration of charge before the Court of Chief Judicial Magistrate, Alo. Full stop. The case has not reached the trial as of now. You can add this paragraph in between before I had said quash the so and so. Okay, so and so the petition is disposed of. Normal here changes here and there. I'll do. Thank you.
Deeply obliged.
Please, my lord.
This is what?
May I please, my lord. My lord, this is a petition for setting aside and quashing of FIR number 40 of 2025 dated 21/3/2025, lordship. So the offenses.
No charge sheet has not.
No, not yet. The offenses alleged is under section 316, subsection 5, criminal breach of trust, section 61, subsection 1 and 2, criminal conspiracy, section 318, subsection 4 for cheating, lordship. So may I take lordship to page 32.
You said cheating, breach of trust,
criminal conspiracy,
criminal conspiracy. Okay.
and section 3, subsection 5, it's common intention.
Huh?
Common intention.
Intention. There are other, so many accused.
2 accused persons.
Big.
Lordship, type copy of the FIR is at FIR is at 35, lordship. It's the original FIR.
Original is readable, I can read it.
Yes, may I read, lordship? Page 35, lordship. FIR regarding criminal conspiracy, dishonest misappropriation of property, criminal breach of trust, forgery, cheating, forgery of valuable security, fraud and misrepresentation by Mr. So-and-so and Messrs. Rank Project and Development Private Limited, represented by its managing director. I, Sri So-and-so, am submitting the following complaint for your kind consideration and investigation. Mr. So-and-so approach.
Your name is, what are your names?
Petitioner
Your Semi,
Sahaya Nirmal
Nirmal
and S. Vinod Kumar.
Huh?
And S. Vinod Kumar is the MD. There is 2 petitioners in this.
Now, what is the name of the other one?
Other one is S. Vinod Kumar.
S. Vinod Kumar.
Yes.
Okay. S. Vinod Kumar.
Lordship. Mr. So-and-so approached Messrs. Somin Infratech, introducing himself as a designated consultant specializing in securing contract work across India or abroad. He claimed to have successfully secured contracts for several major companies in India. Second, Mr. So-and-so agrees to provide his service to the firm to have infrastructure project in India from government agencies, private company. In this regard, he will prepare all the requisite tender documents on behalf of the firm, arrange in getting the firm empaneled with agencies offering the project and participate in tender works. Additionally, Mr. So-and-so, the present petitioner number 1, demanded consultancy fees of rupees 20 lakhs to secure contracts and scheme, assuring that if he failed to secure the contract within 6 months, he would refund the amount with interest. In this regard, Mr. So-and-so issued a signed check of rupees so-and-so in favor of Mr. Somin Infratech. After believing his...
Lord Yu was supposed to get the work done, right?
Yes,
He
he's
consultancy fee of rupees 20 lakhs.
20
to
lakhs, yes.
secure contracts,
Lordship.
assuring us that if you fail
Yes.
to so and so, you would refund the amount.
Yes, after believing his assurance, we transferred 20 lakhs in 5 installments as agreed upon. Thereafter, Mr. So-and-so introduced Messrs. Rank Project Development Private Limited to Messrs. Somin Infratech. Somin Infratech is the complainant, Lordship. Stating that, and Messrs. Rank Project and Development Private Limited is, the managing director is petitioner number 2. Is one of the accused
So
persons.
managing director of Rank Project.
Yes, yes.
He is Vinod Kumar.
Yes, yes, Vinod Kumar. Now, stating that so-and-so was executing large-scale project, including a project valued at approximately 101 crore, 45 lakhs, 45 lakhs in Cebu, Assam for such and such university. Subsequently, Mr. So-and-so presented a work order worth rupees 56 crore, stating that the project involved the construction of Sri Arvind Deva Sports University in Assam. He clarified that the total project value was rupees 101 crore, with rupees 56 crore and rupees 44 crores for ancillary work. Lordship may kindly mark this para 5, Lordship. Later on, I'll clarify with regard to this particular allegation. Mr. So-and-so assured that they have secured the work for rupees 56 crore, and they have had secured the L1 bid and a letter of acceptance for the remaining 44 crore. Memorandum of Understanding and Agreement. The following agreements were made on 29 July 2024 at Naharlagan between the parties. So these are the contents of the agreement, Lordship. Memorandum of Understanding and subcontract agreement between Messrs. Rank Project, pre-bid Memorandum of Understanding. After signing the agreement, Mr. So-and-so and his associate requested an advance royalty fees of rupees 1 crore to be transferred to Messrs. Rank Project. They assured that escrow account would be opened in Itanagar to handle payments, and the team Messrs. Rank Project shall hand immediately over the entire work on the day of signing of the agreement, and also give authorization to the
entire work was shall hand immediately over the entire work to Somin.
Yes, Messrs. Somin in first. Despite assurance, no escrow account was opened, no authorization letter was issued, the work was never handed over as promised. Attempts to contact them were unsuccessful. We were further misled. In good faith, we followed their instruction to mobilize our resources and machineries. However, upon arriving at the site, we were stopped by local authorities who informed us that Messrs. Rank Project had not received the award or NOC for the full 101 crore. We faced significant hardship as our machines and materials were stranded at the site for nearly a month. As per the pre-bid MOU, we prepared and handed over all the necessary tender documents to Mr. Nirmal for submission. A sum of rupees 65,000 was transferred to 65 lakhs was transferred to Messrs. Rank Project on instruction of S. Vinod Kumar, Managing Director of Rank, for the earnest money deposit and the tender fee. Shockingly, we discovered that Messrs. Rank Project and Development Private Limited, represented by the petitioner number 1, petitioner number 2, had never submitted the tender despite the transfer of such and such amount as EMD and tender fees. Upon realizing the fraudulent nature of their actions, we sought a refund of money they had fraudulently obtained through misrepresentation. In response, Mr. So-and-so issued a check of 1 crore 79 lakhs 60,000 and rupees 27 lakhs 20,000, which was also dishonored 3 times. After several months of unfulfilled promises and attempt to reach them, we have been unable to recover the 2 crore 66 lakhs that was fraudulently taken from us under the guise of non-exist project. Therefore, I respectfully request your immediate intervention, registration of FIR.
But Sahaya has returned some money, right? But then those were again dishonored.
Lordship, this is the allegation. The reason, Lordship, why I have mentioned this particular para, Lordship, with regards to para 5, Lordship. There, the informant.
5 of the complaint.
Complaint, yes. Their informant has stated that the work was around, the cost of entire work was around 101 crore. But the actual fact, they have presented the distorted fact. The reason is, the reason why I'm saying is, there was a contract work of, they have of course mentioned 56 crore. That is with regards to construction of certain building, Lordship.
They have like separated it, you see, subsequently
Yes, they have,
presented a work of 56 crore.
yes, one is 56 crore and one is 44 crore. Now, they have mentioned 56 crore and 44 crore, Lordship.
Total project is 100.
101 crore. Now, there is a slight misrepresentation. In fact, it is a misrepresentation by the informant, Lordship. What it happened, Lordship? This petitioner number 1, he was a consultant firm. Petitioner number 1 is a consultant firm, and he was approached by the informant to get him a work. And there were certain agreements, and subsequently they have entered into an agreement, Lordship. Agreement is at Annexure 5, Lordship, page 45.
This
So-
is the agreement between the informant and the firm.
Firm, yeah, petitioner.
Accused, petitioner number 1.
Petitioner number 1, consultancy firm. Lordship, what did happen? This he was asked to get a work within a period of 6 months, and later on there was an agreement that the consultancy firm will also become an executing partner. So accordingly, within a span of 2 months, he has got the work from this consultancy firm, has managed to get a work from petitioner number 2, Messrs. Rank Private Limited. Now, accordingly, they have this
Petitioner number 2 is the Vinod Kumar.
Yes, MD of that farm who was supposed to give the work.
He is the MD of Rank Projects.
Yes.
And
Now,
this,
there was an agreement between informant and petitioner number 1.
complainant is Somin.
Somin, yes.
From where the contract was taken.
Yes, contract.
Somin is, yes.
Somin is the prospective subcontractor.
Subcontractor.
Subcontractor. Now, Somin and this consultancy firm entered into an agreement, and agreement is at page 45, Lordship. Page 45. This was
That means
entered.
Rank will do contract for Somin.
No, Lordship. Somin is just Rank is a private limited company having annual turnover of 165 crore. And this Somin, Messrs. Somin Enterprise is a petty contractor. I mean, they used to get subcontract works from various companies. So that was the reason Messrs. Somin Enterprise approached Nirmal, who is the petitioner number 1. And thereafter, there was an agreement that you have to get me a work within a period of 6 months. So in that, in consideration of that, the Somin was ready to pay 20 lakhs rupees. Now, accordingly, petitioner number 1, being the consultancy firm, has found the work within a period of 2 months. And thereafter, they entered into an agreement, which is at page 45. Page 45, Lordship. This is the agreement between Nirmal and then the informant. Now, as per this, Lordship, if I may take Lordship to page 48, clause 5 of the agreement.
Clause 5 years.
5 years. That the firm first party agrees to pay a retainer fee of 20 lakhs for 6 months to the consultant party.
This party is the
Somin Enterprise.
Somin, yes.
Present.
What? First party agrees to pay a retainer fee of so and so. Okay.
Yes, for 6 months to the consultant, second party, which will be deducted for the consultancy fee after the project is awarded. This retainership will be valid for 6 months. In this regard, second party had agreed to give signed check of 20 lakhs in favor of first party. The agreement was that he had to, for the consultancy, the first party, which is the informant, will pay 20 lakhs as a retainer fee. And then second party has also agreed to
Return it back.
agreed to sign a check of 20 lakhs. That is in case if the work is not awarded to the first party.
In case the work is not.
Yes, yes. So subsequently after this, Lordship, may I take Lordship to straight away to Annexure 8, which is at page 56, Lordship. Now, pursuant to this agreement, the rank Somin Infra Limited and Infratech and then the informant and petitioner number 2, MD of rank project, they have entered into a subcontract agreement, page 56, Lordship. Now, as per the subcontract agreement, Lordship, this agreement is related to, Lordship, 56 crore work, which I have earlier mentioned, Lordship. That is construction of certain building, Lordship. So, Lordship may come to page 57, Lordship. First, second, third para, Lordship. Whereas Public Works Department, Building Wing, Government of Assam, had invited tender for construction of Sri Aniruddha Deva Sports University as Chabua, Assam on EPC Mod 3 basis, hereinafter referred to as work, has awarded the project to RPDPL, that is Rank Private Development Limited, yes, for a bid of rupees 56 crore 62 lakhs 50,960, and the same has been accepted by the client by letter of acceptance dated number so and so, dated so and so.
So this is in respect of the contract work amounting to 56 crore.
56 crore, Lordship. And
what about the other?
Other one?
It's 101 crore of project work.
Yes, now may I take a Lordship to page 60 of the same agreement. Here for subcontract agreement, there was a profit sharing clause. So as per this, Lordship, may I read, Lordship? The royalty fees for RPDPL shall be 9% plus applicable taxes on bill amount of on bill to bill basis. In this regard, the parties agree to open an escrow account at Itanagar. All the payments received from client will be directly deposited in the escrow account. The account will be operated by Somin Infratech. 2 crores in 2 tranches, 1 crore each will be paid on signing of agreement and first RA bill. This is in addition to 9% royalty. So for this subcontract agreement, first, after signing of agreement, they will have to pay one CR. Total it was 2 CR. And then first 1 crore will be paid after signing of agreement and along with in addition to 9% royalty. So total was 2 CR, Lordship. That is the consideration amount for entering into a subcontract agreement. So after this, Lordship, this is with related to 56 crore. Now, why I have said that they have misrepresented, and in fact, they have not given the correct actual fact, Lordship. Now, may I take Lordship to page 85, Lordship?
Now, this is a quashing of the FIR.
Yes, Lordship.
And as you know that if the FIR discloses the ingredients of the offences,
Lordship,
then there cannot be any quashing.
Lordship.
Prima facie, if it shows the ingredients of the offences.
Right.
And of course, the accompanying documents.
Yes.
This is what the Supreme Court has said.
Lordship.
So, these accompanying, I need not go very detailed into the matter.
Lordship.
Prima facie, I'll see whether the FIR makes out a case.
Lordship.
Cheating, trust,
Lordship.
as well as what? Criminal conspiracy.
Yes.
Your cheating part has to be from the inception.
Lordship.
The escrow account and all were not opened, it is said.
Lordship, that is the allegation, Lordship. That is what
I'll have to go by the allegation. Allegations will be proved in the trial.
Lordship, that is why I am pointing out these MOUs. These subsequent MOU also, upon their insistence, even here, what their allegation is, they in the FIR, they said that for the work which has not been awarded, but 56 crore work, Lordship, I'll Lordship point it out, 56 crore now has been awarded and we have been receiving notice, and in fact, I have been told that the contract has been terminated by the PWD. for non-initiation of work. That I'll that I'll show, Lordship. Now I am on the remaining part, 44 crore, Lordship. Now these, even in this agreement, Lordship, I'll point out the relevant para, Lordship. 86, page 86, Lordship.
Yes.
May I read, Lordship?
1 second. 86.
Yes.
Hmm.
The allegation is that the work has not been awarded. But here, if Lordship see the subsequent agreement between the informant and the petitioner number 2, Lordship, whereas Public Works Department, Lordship, building had invited tender for establishment of such and such construction of rising low site, yes, art cutting,
This is for art filling and construction of boundary wall.
boundary wall, gate,
Earlier was
yes.
different. Earlier was the
Construction of the building, Lordship.
construction of the building.
Yes. Now,
Okay.
Lordship may come after this, Lordship. RPDPL has received L1 of the above project, and LOA is issued after rebate as per client. The value of project may vary from bid price of 44 lakhs. So here also it has been clearly mentioned that subsequent work, the petitioners participated in the tender process. He was the only bidder, so he was adjudged as L1. And even in the contract agreement, it is clearly mentioned that he was just adjudged as an L1, and then there was a rebate process. Only after that, since he was the only lone bidder in the subsequent call of tender, Lordship. Initially there was tender, but that was again cancelled. And subsequently,
This is cancelled, where he was rated as L1.
No, that is the subsequent tender.
Okay.
He became L1 and he was the only bidder in that particular tender. So because of that, there was a rebate process with the department, Lordship. That is the reason why here it has been clearly mentioned that L1.
No, he is okay, rated as L1, but then further process has to be undergone before allotting the work.
Lordship,
Before allotting the work,
yes.
the entire tender process is not over.
Yes, Lordship, that is what I'm on to. They are saying that they have entered into contract for this work. Now, here, Lordship, if you see in this agreement, Lordship, there is no mention of 2 crore, Lordship, in the commercial profit sharing agreement, Lordship.
Yes.
Lordship may come to page 91. Page 91. 18.0, Lordship. The royalty fees of RPDPL will be 7% and applicable taxes and check of so and so. In this regard, party escrow account at Itanagar, all payment received from client will be directly deposited in the escrow account. The account will be operated by S Infratech. S Infratech shall pay an additional 4% amount on award cost of the project.
Okay.
So here, now what I wanted to point it out is, Lordship, that 1 crore which has been alleged to be, paid, Lordship. No, I'm not denying that I have not received the amount. I have received that amount as a consideration for the previous contract, which 56 crore contract. Now, with regards to this contract, since work has not yet been awarded, it is upon their insistence we have entered into this agreement, because that boundary wall and all, so they found that to be a profitable Lordship business. So they kept on insisting on, only because of their insistence. And then in this agreement, Lordship, it is clear that only after awarding of contract, that's why there is a mention of the amount may vary. So one CR and 20 lakhs to the petitioner number 1 and 1 CR to the petitioner number 2 was paid in consideration of, Lordship, contract work number 1. For the MOU which they have signed earlier for 56 crore work. Yes. Now, my contention is, Lordship has rightly pointed out that there has to be some prima facie material. Now, if we go by this agreement, there is no question of criminal breach of trust or criminal cheating. That has to be from the beginning. For cheating, to make out an offense of cheating, there should be that inference can be drawn from the beginning. But if we go by the entirety of this is a civil dispute, Lordship. Now, this has been given a color of this criminal, Lordship. Now, there is a in case of Lordship, in page, in the subcontract agreement itself, page 56, Lordship, page 63, Lordship, of the subcontract agreement, there is a clause for Lordship arbitration in case of any dispute. Page 63.
They can go for arbitration.
Yes, and then Lordship.
Now we are concerned only with this criminal aspect of the matter.
Lordship. Now,
And, criminal aspect, because there are
Lordship, now the another issue is, Lordship, with regards to this work, after signing the contract, after mobilize, they have said that they have mobilized everything. But it was his executing partner, the petitioner number 1, who has mobilized the material. Even after taking over the work, Lordship, Lordship may kindly come to page 82, Lordship. That is the notice issued by the PWD.
it's okay. Today I'm not finally disposing of the matter.
Lordship.
Today you are praying for some interim.
Lordship, yes.
What do you say, Mr. Loy?
It's appeared to be the civil dispute. It appeared to be the civil dispute.
But then the cheating part is there. In
Lo-
fact, of course, he has shown that those agreements have been undergone between them, has been entered into between the parties. But the fact remains, notice will be issued. Records are, I don't think so it's necessary because I'll go with the complaint.
Lordship, if Lordship may allow, because after registration, we are on the receiving end, in fact, Lordship. I am a company of annual turnover of 165 crore, Lordship. And then my reputation has been tarnished because of this giving a criminal color to the contractual dispute. In fact, they have filed this after unilaterally withdrawing the project. They have filed this FIR solely
We will decide on the interim after the respondent
Lordship,
appears. Because normally what happens if I give a stay, of course we have material shown that these
Lordship may
but
come.
then the matter lies for many
Lordship
years.
may come to page 82, Lordship. Annex 10.
We'll fix a short date. Let the
Lordship,
respondent appear.
Lordship, because
And then we will decide on the interim.
Lordship, because of this FIR, Lordship, the petitioner number 2 is suffering because their reputation is at stake. They are allies of something. They have been into this business for the past 40 years. It was taken over by the present MD recently. Now these things have come up, and then because of
We'll
this,
take it up next week.
Lordship, then in the meantime, Lordship.
Next week there will be no difference. Next week I'll take it up.
Lordship may
And in the meantime, serve the copy upon the respondent number 2.
Lordship.
Let him appear.
Lordship.
I'll hear both the side and I'll pass an interim order.
Lordship, in that case, because since I have already, Lordship, pointed out that even the petitioner number 2 is contemplating to file a civil suit for breach of contract.
Yes, that will
But Lordship is aware that in catenas of judgment, Lordship, in
you take bail, there is no
Lordship,
issue. As far as this one is concerned, right, nobody will arrest you, and in the meantime, I will issue notice, and then on the next.
Lordship,
I'll
then
give-
no coercive action. If Lordship is not,
Coercive action is actually not, it's a misnomer.
Lordship,
The Supreme Court has said this kind of order should.
the Lordship proceeding may be stayed.
Undertaking, nothing will be taken done
Lordship,
against you.
Lordship, the issue is the people, this particular company, petition number 2 he is from Chennai. So in the name of investigation, they have been harassed. And in fact, they were called many times. And after registration of their work has been completely hampered, Lordship. That is the reason why I'm praying for interim, Lordship. Their work has completely,
Okay, today I'll give no coercive, but next week, Tuesday, I'll pass the interim order.
Lordship.
Then heard Mr. So-and-so for the petition. And Loy, the additional public prosecutor. This instant petition is filed for quashing of the FIR dated 19/3/2025. Alleging criminal offenses of criminal conspiracy, misappropriation of property, criminal breach of trust in respect of the accused person, in respect of petitioners, number 1 and 2. The police registered the case under section 318. Registered the case under section what? 318, within bracket, what is there?
Subsection 4.
The subsection 4. 316.
Subsection 5.
61, subsection 1, 61, subsection 2, and section 3, subsection 5 of the BNSS.
Yes.
The counsel appearing for the petitioner had placed the memorandum of agreements entered into between the parties, showing that the work has been the contract work has been allotted, right? No, it was,
There is 2 works, Lordship. One,
there are 2 works.
yeah,
The contract work of construction of a building, as well as the construction of the boundary walls. Agreements, the agreements were entered into between the parties for construction of the building as well as the construction of the, where did you show the subsequent contract? Where was the subsequent contract? Yes, yes. So subsequent contract dated, subsequent memorandum of understanding dated. There is no dated. Entered into between in July 2024 for construction of the Sri Aniruddeva Sports University Chabua in Dibrugarh, Assam, raising low site, construction of boundary wall, gate, RCC covered drain, box culvert, and topographical survey works. And as such, he has submitted that there is no cheating or breach of trust as alleged in the FIR. Issue notice to respondent number 2. Steps to be taken, petitioner to take steps by registered post with AD, as well as normal, as well as usual process, or by Dusty. Dusty is not allowed actually, by usual process, within a period of 3 days to 2 days from today. It is a subtle position of law that if the first information report discloses ingredients of the offense charged, the same may not be quashed. However, if the accompanying documents proves, prima facie shows that the offenses are not maintainable in the eyes of law, the quashing petition can be entertained. In view of the deed of agreements shown by the counsel appearing for the petitioners, it is directed that till the notice is served, no coercive action should be taken against the petitioners. Full stop. List the matter after. In the next week, if you can, if the service can be done.
Notice, Lordship.
List the matter after 2 weeks. In the meantime.
Lordship.
no course of action, although it is not.
Lordship, that is the reason why I was praying for stay, Lordship, stay of the I
Without
mean,
hearing him, it
the
is
proceeding.
difficult.
And next, it may be fixed for final disposal if the parties come, because Lordship, there is a order from the while granting anticipatory bail, the Sessions Court had directed the accused person to cooperate with the investigation. So considering that condition, they are being frequently called to Arunachal Pradesh. They are working at Chennai, and they are being frequently called by the investigating agency in the name of investigation, and they are made to stay for whole day. So their work has been severely hampered. For the
Okay, I'll think over, I'll pass the necessary order in the chamber. Stay part, okay?
Lordship,
Or if I don't give stay, then no course of action, okay?
Lordship. Deeply honest.
This is also quashing.
My lord. On merit, my lord, I am challenging my lord. It is pertaining to my following criminal, all the this criminal proceeding it is out of following PS case number 4 of 2014, my lord, under section, my lord, 166 A IPC, my lord, read with section 134 of RP Act, my lord.
So what is the offense? Let me go to the FIR.
FIR, my lord, will find at page number, my lord, annexation number 1, my lord. This page number 28, my lord. Page number 27, 28 is the FIR, my lord. 28, my lord. In lieu of the upcoming simultaneous election 2004, type out, my lord, will find at page number 29, my lord. Type out, my lord, of this, my lord. The following officials are reported for the willful neglect and refusal to discharge the election duty and responsibility assigned to them, since they refuse to attend the polling duty on the day of
Discharge.
they have a regular case under, my lord. The allegation, my lord, we pay to discharge the election duty.
For?
I am at serial.
Taga, your name is here?
Yes, my lord. It's serial number 11, my lord.
Okay.
My lord, let's see, my lord. There's 23 accused, my lord. Now, after investigation, my lord, only 15 was arrested, my lord, in this case, my lord. Out of 15, my lord, 10 were discharged by.
There are 23 in total.
23, my lord. Out of that, only charge sheet was filed against only 15, my lord. And out of 15, my lord, 10 were discharged by the Larder court below, my lord. And 1, my lord.
10 discharged.
Discharged, my lord.
Discharged while framing of charge, they were discharged.
Discharged, my lord. And 5, my lord. Out of 5, my lord, 1, my lord, has been case against 1 has been interfered by this honorable court, my lord.
What happened to 1?
1 that is interfered in criminal petition 167 of 2024, my lord, by this honorable court, my lord.
First.
Similar to my case, my lord. There is was criminal petition 167 to them order.
You have annexed the order?
Yeah, I have annexed the order, my lord. Annex, my lord, will find at page number
130.
130, yes. Operating part is 132, yes.
Where is his name in the shift chart?
Sir, my lord, at page serial number
17.
17, my lord. Same FIR. In similar situation, my lord, that interfere, my lord. I am reading from my lord, page number.
It's okay. FIR, then charge sheet. Where is the charge sheet?
Charge sheet, my lord. Start from page number, my lord.
31. It's already one. We'll take it up at 2 then.
Pardon, my lord.
We'll take it up at 2.
My lord.
Mr. Majumdar, we have to wait. He's not here. At 2, after this, Mr. Majumdar's matter. Mr. Majumdar, sorry for keeping you waiting. I'll take it, your matter immediately after this. Okay. Yes,
Your Lordship, I beg to mention item number 8.
8.
Yes, Your Lordship.
This is actually not a bank to me.
Yes.
8 is a petition. What happened?
Kindly, this matter may be adjourned for today. As in this matter, we are supposed to file affidavit. However, we do not file it yet. So 2 weeks time may be given for filing of affidavit.
As prayed for by
And
Ms.
Honde.
So-and-so on behalf of
Titaba.
items 8, right?
Yes, Your Lordship.
B Taba. I'm B Taba. The prayer is as prayed for me that she has to file the affidavit. She was supposed to file the affidavit as ordered by on the last occasion, but she is unable to. As such, she prays for some more time to file the affidavit, listed after 2 weeks.
Yes.
As well.
Deeply obliged, Your Lordship.
Your Honor, I beg to mention item number 15. I'm
Item
so sorry, Your
15.
Honor. Yes, Your Honor. In this item, I'm appearing for the first time for the respondent, Your Honor. I've already filed my wakalatnama.
You are yet to file your wakalatnama.
I've already filed, Your
Acha,
Honor, and I'm
okay.
appearing for the first time today. Since I have some emergency and I have to go, Your Honor, I'm mentioning this matter because it might take some time.
My lord, I am appearing for petitioner here in this place, and there is interim order, my lord.
That will continue till the next date.
Yes, ma'am.
You are for the petitioner.
No, I am for
I'm
the
for the
petitioner.
You are for the
respondent.
respondent. Okay, heard Miss so-and-so and so-and-so. He is for the petitioner, she is for the respondent. And then a prayer is made by so-and-so appearing for respondent that she has filed the wakalatnama today and that she needs some time to go through the matter. Prayer is allowed. The interim order passed earlier shall continue till the next date. List the matter after 2 weeks. Okay?
Deeply obliged.
Yes, I'm
Yes, yes. What was your item? Wait.
My lord has seen the FIR, my lord.
Okay.
FIR under 166A, my lord, IPC, my lord, and 134 of RPX, my lord. Now, at page number 51, my lord, you see, my lord. Charge sheet was also submitted same section, my lord.
Where is the FIR?
FIR, my lord, at page number 28, my lord.
Huh?
28, my lord.
Yes. Oh, yes, I've gone through the FIR.
Yes,
Yes,
ma'am.
huh?
So,
They
allegation
were
is-
not discharging their duties during the election.
Election,
time.
that is allegation, my lord.
Okay.
At page number 51, my lord, this is, I'm not reading the whole charge sheet, my lord. This is body of charge sheet, my lord.
51.
51, my lord. Last, my lord, para, my lord, second line, my lord. Is such
Okay,
prima
wait a
facie
minute,
case
got
will
it.
establish against
Just a second, just a second. What happened? 51, there is no page 51 here.
5-1, my lord. Page number 5-1.
Vanessa. I've not been able to get it over. No, 51 page is not here. What happened? 50 and 52. 51 is missing from my petition, from my copy. Achha. No, the pagination is wrong. 52 I have.
No, no, my lord,
Yes.
this is 51 actually.
51, my lord.
51. After that, 52.
This, okay. This is 1.
No one, my lord.
It
It's
look like
like-
2.
Yes,
my
my
lord.
lord. Sorry, my lord.
Okay.
It look like 2.
51. Okay.
Last
Huh.
para, my lord, second last line, my lord. Is such prima facie case is well established against the following 15 LS accused person out of 23 and the section same similar, my lord, 166 AIPC read with 134 happy, my lord. Now, my lord. Yes, I am on my lord merit, my lord.
You are at serial number
Yeah, I'm at 7, my lord, 7.
Tasataga.
Yes, ma'am.
Tasataga. Okay, 7.
Out of this, my lord, so already I have submitted, my lord, 10 discharge, my lord, while at trial coffin.
You said. Okay.
Now,
Where is that?
order that,
Initially there were so many, right?
yes, ma'am, 23, my lord.
Uh-huh.
Out of 23,
12 were charged.
15 were,
Oh, 15 were charged.
charge sheeted.
Okay, charge
Of
sheeted.
that, 10 has been discharged, my lord. That order I have annexed, my lord, at page number. Start from page number, my lord.
Facts are same in respect of all the petitioners,
Same,
all the accused persons.
Same
Same FIR.
Now,
On what ground? I mean, why that difference is made? 15 are charge sheeted and rest are left out. What is the difference between their cases?
different, my lord, that,
Show me the charge framing order where you have been, where few of them have been discharged.
page number 79, my lord. Start from 79, my lord. 79, my lord.
Okay.
Property part, my lord, will find it 91, my lord. All
91.
no. Start from 90, my lord. 90, my lord.
Considering the specific submissions.
Yes, my lord.
Yes.
In the last para, my lord, in the line of IA number such and in following PS 424 are hereby allow and accuse.
Show me the regions.
Region.
Those are the conclusions.
It's a summon case, ma'am.
Huh?
Summon case.
This is summon.
Summon case, your lordship. No require for framing of charges, ma'am. That's why, your lordship, there is no specific order.
Ground, my lord, is all the out of 14 accused, my lord, ground are different, my lord. One ground on the medical, my lord, other saying, my lord, on the medical of family, my lord. That is that whole separate issue raised, my lord. That start from, my lord, we'll see at 81, my lord. Page last for 81, my lord. 81, my lord.
Yes.
Last para, my lord. In last para, my lord. In the submission of the engaged counsel accused such and such, he has such his name from such and such due to miscommunication at his department office of DMO following his since his name was not reflected, due to which neither he was allowed to attend any of the training or even cast his vote in postal ballot, which has been reflected in the charge itself submitted by the IO. That is underground.
He got discharged.
Yes, sir, my lord. Reasonable. And
Then
last para, again last para, my lord. Same page, my lord. 82, my lord. APM court of accused submitted having pursued a case record. 3 APR genuine miscommunication with the department concerned itself, and hence submitted he has no objection against discharge Nangram Sab and Sasan.
So Nangram Chadap. So Nangram Chadap, okay. He has changed his name, so he could not be charged. Then what about others?
Others, my lord, at page number 83, my lord, one accused, my lord, engaged counsel for such and such, submitted accused is
okay.
suffering from acquired demyelinating syndrome, my lord, and panic disorder.
Due to medical reason.
Medical reason.
Then
same, my lord,
Ipasama,
my lord.
wrongly charged sheeted.
Wrongly charged sheeted. And 84 also.
In fact, attended all election related training.
Training, my lord.
Okay, then Johnny, wrongly charged sheeted. Was a contingency. He resigned.
He resigned from service, my lord.
So he resigned from service. So on these grounds, these people were left out.
Labor, my lord. At page number 86 also, my lord, that is, there is a grant for medical 86 also, my lord.
One is lactating mother, so okay.
86 also. 86, my lord.
Tadar Tai.
Yes, he was discharged on also on medical ground, my lord.
So what is your ground then?
I was also at that point of time also on medical, my lord.
You had given your application.
Yes,
to
my
the
lord.
concerned authority.
Yes, my lord. Concerned authority.
Where is that?
That, my lord, will see at page number, my lord. Page number 113, my lord.
Yes.
113, my lord.
This was given on to the district 28-3.
23, my lord.
And when was the election?
Election, my lord, was on, my lord. In this part, it was on, my lord.
Where was the FIR?
FIR on 17 April, my lord. 17 April. 17 April.
FIR is 17 April, but
My-
when was the election? 2024. Now here it is March.
May I read this, my lord? 113, my lord. 139. May I read this, my lord?
100?
113, my lord.
113 is there. You had made the application on 28th of March 24.
My lord.
No, I just wanted to see whether this was before the election.
No, my lord. Thereafter, my lord. Thereafter. Election was thereafter, my lord.
Election was thereafter.
Thereafter.
That
I
is what-
indicated at later part, my lord. I'll indicate it also, my lord. Yeah, with record, my lord. 28/3/2024, my lord. I have submit, my lord. Sir, with due humble submission, I would like to request you for kind necessary action that I am suffering from multiple seizure disorder, which have happened randomly, making me unconscious. Pain, liver result in headache and dizziness since last 5 days, making me almost bedridden and unable to daily source. From the above reason on dated 25/3/2025, I have been taken to Trins Naharlagan by my family member for my immediate proper treatment and diagnosis, which was endanger my life. I was diagnosed for a seizure disorder, fatty liver, headache and
Okay, I've
dizziness.
read. And so this was received by the nodal officer.
Nodal officer, my lord. Now thereafter, my lord, at page number, my lord, you kindly have a look at page number 119, my lord. 1119.
119, yes.
No.
Hmm?
Now, after this application, also, my lord, my name was listed in the duty list, my lord. Accordingly, I submit another representation, my lord, saying that, my lord,
Okay.
and for my lord. Reference, my lord, my earlier representation dated 28/3/2014 for exemption on election duty on genuine medical ground. Again, this is submitted.
Okay.
After submission of this, my lord, this order was issued, my lord, at page number 10, annexation number 10, my lord.
Wait, surprised to see my name in the complete party duty order.
Yes, madam.
Then what?
After that, my lord, will see, my lord, this is order annexation number 10, my lord. Annexation number 2, this is dated at 12 April 2024, my lord.
Which one?
Annexation number 10, my lord, page number 120, my lord.
Yes.
Now, this order was issued by the returning officer, my lord. Now, here my name is not there, my lord.
Not there?
No, accordingly, I assume, my lord, yes, my representation is acted upon, my lord, and I was my name is not there. I will be at the most at page number 129, my lord. My lord will kindly have it 129, page number 129, my lord.
129.
My lord.
Okay. Yes.
Further, those names, my lord, that had not been shown or list in the above mentioned order, who have been earlier appointed with such and such, are directed to be ready to perform election duty as presiding officer as when called upon, my lord. No officer shall be leave. Now, this is the order, my lord. Now, my name is not here in this list, my lord. Now, thereafter, no, my lord, appointment issued to me, my lord. No, any other appointment was issued to me.
After that, nobody was called.
No, my lord. So, therefore, my lord, my humble submission, this case, my lord, is I am testing on merit, my lord. Two, my lord, has seen, my lord. Two section, my lord. 166A, my lord. IPC, my lord. My lord, will kindly have it look
Show
at
me that.
166A, my lord.
And also representation of people. 150.
Now, this section, my lord, I humbly believe, my lord, in whole case, my lord, this case not, this section is not attracted, my lord. 166, my lord.
So that knowingly will not come.
No, my lord. Public servant disobeying direction under law, my lord. 166A, my lord.
Knowingly disobeys. So what you are saying is ingredients are not attractive.
Not knowingly only, my lord. This I believe, my lord. If this section is applicable only to the public servant, my lord, who has been duty of some investigation and inquiry, my lord. Not in the normal case, my lord. If I may allow to read this, my lord. knowingly disobey any direction of a law which prohibit him from requiring the attendance of any place of any person for a purpose of investigation into an offense or an other matter.
Or any other matter is there?
No, it is a section, I believe, my lord, where in the case like in under the law, my lord, normally like my lord, boxer victim, my lord, cannot be called in the police, my lord. They cannot be investigated in a by wearing uniform, my lord. That when such or is violated in such situation, this will be attracted, my lord. Knowingly disobey any direction of law, who is my lord, or habit, my lord. My lord is kindly note this for habit word, my lord.
Your interpretation would not be correct. Here, whoever is a public servant knowingly disobeys the direction of law, or he does not appear somewhere where he should appear.
No, my lord, it say I knowingly
Of course, you can say that this is not this particular petitioner has not knowingly disobeyed.
Yes,
He
my
has
lord,
given the application.
that is my additional ground, my lord. That is my additional, but my humble understanding of this, my lord, it is it knowingly disobey any direction of law, my lord. Who is my lord? Simply not direction. Who is prohibit, my lord? This need to be read as whole, my lord. Knowingly disobey any direction of law. Who is my lord? Prohibit, my lord. Him.
Which
From
prohibits him
requiring
the attendance at any place
or of investigation. Suppose in a FOSCO case, in child investigation, like my child need to be not take statement by wearing uniform, my lord. In such situation, that can be, my lord, also be also, my lord. Kindly have a look at be, my lord. Knowingly disobey to prejudice of any person, any direction of law regulating the manner in which he shall conduct such investigation. Fail to record any information given to C, my lord, under subsection 154 C in related to congregation for. Now, I believe this section is particularly a situation where, my lord, law authorized a public officer to investigate or inquire, my lord, in a matter, my lord. And if concerned officer, my lord, did not follow the specific direction prohibited under the law, my lord, this section is attacked. It is not simply disobedience or disobey of the order, my lord, will not attract this section, my lord. I humbly believe, my lord.
But then that or any other matter, there where adjustive generis comes. So this any other matter.
In any other also, my lord, there should be some prohibition, my lord. My lord will see law which prohibit, my lord. Law which prohibit, my lord. In my case, there is no prohibition, my lord. I was directed to engage in election duty, my lord. Here is a, my lord. It attract when law prohibits some, my lord, doing of a thing to be done in particular way, my lord. And law prohibit, my lord, the concerned officer, my lord. There will be some prohibition, my lord. Now, in my case, there is no prohibition, my lord. I was simply directed to engage in election duty, my lord.
Do you have any judgments on that?
No, my lord.
Okay. Then what else?
Now, other, my lord, RPF, my lord.
RPF is there. One
134, my lord.
Send me your book.
May I read 134, my lord? It's my breach.
Read it slowly.
Breach of official duty in connection with election, my lord. If any person to whom this section apply is without reasonable cause, my lord. My lord will kindly note, is without reasonable cause guilty of any act or omission in breach of his official duty, he shall be punishable with fine which may extend it to 500 rupees, my lord. This is now, my lord has seen, my lord. My lord.
Here, what is the punishment?
500 rupees, my lord.
No, here 156 shall not be less than
6 months. 6 months, my lord. Now, my lord has seen my situation, my lord. My situation on medical ground, my lord, I have reported the concerned authority, my lord. Now, similar situation has already tested by this ordinate base of this honorable court, my lord. On medical ground, my lord will kindly have a look at that also, my lord. At page number 131, my lord.
This is in respect of another person
yes, my
Rinku Jacob.
From 5, I am reading, my lord. 130 and last paragraph. Now, petitioner has decided a proceeding by way of present petition. 6, my lord. The court is
Which paragraph you are reading?
My lord.
Paragraph?
Paragraph 6, my lord. Last, my lord.
This spot has produced the materials.
My lord. Is in the documents available report. Peruse the material so that statement of record by the IO and after completion investigation, such it also filed being such number such and such. 7, my lord. If material so collective IO is taken in page value, it to be taken correct. It's seen that the petitioner had explained his inability to attend the election duty for the reason of his serious health condition, my lord. Serious health condition. In as much as non-attendance was not delivered, one the petitioner could not attend the duty for reason beyond his control, my lord. So in similar situation, my lord, High Court has interfered with that. My case also, well, I was seriously suffering. I have intimate death to reason. So at this stage, my lord, my humble submission, my lord, let no as other respondent is there, my lord. And let notice bigger.
Mr. Ete,
Yes, my
what
lord.
do you have to say?
My lord, so far as your lordship 166A is concerned, my lord, my lord, we have to understand this provision in context of investigation. My lord, may kindly see the 3 sub clauses are there. May I read, my lord? The first says, knowingly disobey any direction of law which prohibit him from requiring the attendance at any place of any person for the purpose of investigation. Into an offense. Now, your lordship, we need to see the investigation part. What is the definition of the investigation here, your lordship? Who will come? The investigation is generally conducted by the police officers or any other person authorized by the law except the magistrate, my lord. So now, your lordship, the investigation
is which is not trial or.
Yes, exactly. Yes, exactly. Now, your lordship may come to the second part, B. Knowingly disobey to the prejudice of any person, any other direction of the law regulating the manner in which he shall conduct such investigation.
Can investigate.
Yes, my lord. Now, the letter again. Or fail to record any information given to him under subsection 1. That is it's indicating again
FIR.
Of FIR, CRPC, so and so, in relating to cognizable offense, punishable under section 326, so and so, so and so. So now, your lordship, it's in fact the sections deal with the investigation part, because there are certain offenses or certain procedure for which the police are prohibited from exercising the certain thing. Your lordship, 163 is also there where it is said that statement should not be recorded by inducing the witness, my lord, the accused also. So it's prohibited, my lord, for which even the sanction is not required, your lordship.
Means if he does not obey,
Yes.
if he disobeys any order,
Yes, your
which
lordship.
prohibits him from appearing somewhere.
No, your lordship, which prohibited him from requiring the attendance of any person, my lord. Your lordship, may kindly see, your lordship. Any direction of the law which prohibited him from requiring the attendance
So means
of
if he
any
has to-
person.
If he has to call someone
Yes, my lord.
somewhere.
Yes, your lordship.
And it is prohibited.
Yes, your
He
lordship.
cannot.
Yes, my lord. Yes. For the recording of the statement,
And he
for example.
disobeys.
Yes, your lordship.
False.
Yes.
Then in that case.
Yes. If suppose, your lordship, the witness is supposed to be called on the police station for 161, but if he is calling in somewhere, your lordship, which is not
Yes,
recognized by the CRPC, then, your lordship, if any complaint is does that, then this section will be attracted.
So
Against
in your submission, this actually doesn't apply to the.
in this
present
case, your lordship, because here is a case where a person has been initially entrusted to for acting as a your lordship, polling officer. So for that, if he failed to refuse to deliberately refuse to obey that order, then, your lordship, it directly hit my lord the section 3 that RP Act 134, and even, your lordship, there are specific chapter for that in relating to election in the IPC, man. So here, your lordship, this section will not attract in this case because he was not entrusted for investigation any matter, any issue. And now, your lordship, so far as the second part is concerned.
134.
Yes, 134 is concerned. Now, your lordship, this honorable coordinate bench has already quashed one of the matter, taking into consideration of the material which has been produced before this court, your lordship. The medical, your lordship, the prescription and the representation. So now, your lordship, 134. Your lordship, it's here, your lordship. Breach of official duty in connection with election. If any person to whom this section applies is without reasonable cause. Now, your lordship, here they literally came for on that ground. Whether they can be prima facie satisfy this court that there exists a reasonable ground. Cause guilty of any act or omission in breach of his official duty, he shall be punished with a fine which may be extended to 500 rupees. Now, Your Lordship, the second part is an offence punishable under subsection 1 shall be cognizable. For this subsection 1A, Your Lordship, it has been registered and investigated by the investigation agency, and they have been charge sheeted also. So the second part is, Your Lordship, no suit or other legal proceedings shall lie against any person for damages in respect of any such act or omission as aforesaid. This is the civil part, damages part, my lord. And the third part is, Your Lordship, the person to whom this section apply are omitted: district judge, district election officer, returning officer, assistant returning, presiding officer, polling officer, and any other person appointed to perform any duty in connection with the receipt of the nomination or withdrawal. Yes, Your Lord. Now, Your Lordship, here the annexer which they are relying, there his name is not there as a presiding officer, because it says this section applies to these officials who were engaged by the election commission, my lord. So now it specifically specifies this.
Initially engaged by the.
Yes, my lord. But later on, Your Lordship, what I have seen from the record, his name is not there in the recent one, Your Lordship.
And where is the document where he was initially appointed?
Yes, I was initially appointed, my lord. I was initially appointed, my lord. That's why, my lord.
Have you annexed it?
They have not annexed it, my lord. What did Your Lordship record?
But I'm not disputing that also, my lord. On the in representation also, my lord, I attended a 2 training, my lord. I am not disputing it, my lord.
That you have written. You have written in your representation that you have
Yes,
attended
madam.
the training.
I appointed. Today also I'm accepting. Earlier I was appointed, madam. In terms of that, I have submitted representation, my lord.
Do we want the records for that? Not required.
Yes, my lord. Yes, absolutely. And Your Lordship, so far as this offence are concerned, this is a summon case, my lord. The punishment is extended up to 2 years. So there is no any stage for framing of charge. However, Your Lordship, when the summon is issued, they can always file a discharge application. So what I've seen from the order, Your Lordship, there is no any binding on the offence. At least when they have made a plea before the court that they have done the discharge this duty, why they failed to discharge the duty, and even on the offence, Your Lordship, the court must have recorded something, Your Lordship, that whether this offence has been attracted or not, my lord. Because there is no requirement of formal framing of charge in the summon case, Your Lordship. It's a summon case. The punishment is up to, my lord, not more than 2 years. So the second part.
This section goes 166A goes 134 goes, but police are always at liberty to add sections or. What I have to see whether the FIR makes out a cognizable case.
Oh, absolutely, madam. Absolutely.
Sections may not matter.
Yes, Your Lord.
So whether it has made out a cognizable case.
That has to
Yes,
be.
my lord. As part FIR 134 is made out, my lord. I humbly consider 134 in as part FIR, my lord. This is made out, my lord.
But 134, whether this is cognizable.
Yes, my lord.
Yes, Your Lord. It is specifically prescribed 1A, my lord. 134 1A. The
134?
yeah, of RP Act, my lord.
Of the RP Act.
An offence punishable under subsection 1 shall be cognizable. So
Yes.
it's a cognizable.
Punishable subsection 1 shall be cognizable.
Yes, ma'am. So it's a cognizable.
Punishable under subsection 1. Right.
Yes, madam.
If any person to whom this section applies is without reasonable cause guilty of any act. Without reasonable cause.
Yes, madam.
He has some cause.
Yes, that is there, my lord. That has been considered by the coordinate bench in the other matter, same FIR, and that was quashed. Now, whether at this stage they can go for parity or whether this court will be inclined enough to take that plea for interference or not, that matter has to be decided by this honorable court.
Any other section that can be applicable in the facts of the case?
My lord, so yeah, in
Election of duty and all those.
Your Lordship, in actually for misconduct, Your Lordship, the departmental proceeding ought to have been initiated. That is totally different otherwise also. But Chapter 9, Your Lordship, of offence by or relating to public servant. There 166A was.
You are referring to IPC?
Yes, my lord.
Or Sanhita?
IPC. IPC.
Okay.
Here, Your Lordship, under this section only it was registered 166A. Now the other sections, Your Lordship, the punishment for non-treatment of victim, that goes public servant. Your Lordship, Your Lordship, from this chapter, I don't think, Your Lordship, the section will be attracted. There is specific chapter for election matter, man.
Do you want some time to see whether any other offense is made out in the FIR? Otherwise, I can dispose it off or I'll issue notice there are some other party.
Yes, ma'am.
Deputy Commissioner, madam.
Complainant, my lord.
The complainant, not required, I think you can appear.
Yes, my lord.
It is in official capacity.
Yes, my lord. That is
Or
there.
government advocate can appear.
Actually, Your Lordship, they ought to have implemented them in person because an informant, how an informant, the deputy commissioner, the incumbent can be any person will come after transfer also.
Government advocate will appear because this is an official capacity. I need not give notice. Government advocate can
Okay,
appear.
Your Lordship.
Or you can also appear.
Okay, Your Lordship. Since they are appearing, Your Lordship.
In the meantime, what your yeah, she's there.
Yes, sir.
So what I'll do is let him check because the requirement is if any cognizable offense may not be these sections. So let him go through. I'll also go through. Then today let the notice go. And otherwise I could have disposed. I'll take it up next week. In the meantime, they'll also see.
Yeah, my lord. My humble submission, my lord. Next date of the case is fixed on 1, my lord. My lord will grant me interim, my lord, protection, my lord.
Okay, okay. Prima facie, you have made out a case. Only that we have to see that. Okay. Heard Mr. The name please, Perme.
Tell for me, my lord.
L. Perme. L. Perme and Mr. T. Ate, government advocate, and K. Wangmu. K. Wangmu. Yes. K. Wangmu, government advocate. This petition is filed under section 528 of the BNSS for quashing the criminal proceeding against the petitioner in GR case number 9 of 2024 arising out of Koliaram police station case number 4 of 2024 registered under section 166A IPC read with section 134 of the RP Act. By which RP Act, full stop. The petitioner has challenged the order dated 7/4/2025 passed by the JMFC, by which the learned court dismissed the interlocutory application filed for discharge of the petitioner. Mr. So-and-so has, Mr. L. Perme has submitted before this court that the FIR lodged against him and other co-accused do not disclose any cognizable offense, does not disclose any cognizable offense, much less section 166A, much less section 166A IPC or section 134 of the RP Act 1951. He submits that there were altogether 23 number of accused persons as arrayed in the first information report, out of which 15 were charge sheeted, and 8 were discharged.
10, my lord. 10 were discharged, my lord.
No,
Oh, sorry.
in the
Yes,
charge.
yes, sorry, my lord.
15 were charge sheeted and 10 were discharged, and thereafter, by the order dated, which order by which?
5/11/2024, my lord. 5/11/2024, my lord.
Page
79, my lord.
5/11/2024, the learned court had discharged another 10 accused persons. he had stated at the bar that there was no dereliction of duty, there was no, there was no, there was no neglect and refusal to discharge the duty on the part of the petitioner. There is only one. There is no neglect and refusal to discharge the duty on the part of the petitioner, as he had given his application on medical issue. Where are the applications?
Application, my lord.
113.
Yes, my lord, 113.
As he had given application to the district election officer, praying therein that he won't be able to attend to his duties due to his medical condition. He had again sent a reminder to the district election officer when his name was arrayed for duty,
My lord.
that he was surprised to see he was surprised to see his name in the duty roster, as he had already applied for leave. The counsel for the petitioner also submits that subsequently an order was issued by the district election officer wherein the names of the officers to report in duty were given. And in that list, the name of the petitioner was not included. And neither he was called for any duty. As such, he prays that the charges under section 166A IPC as well as 134 of the Representation of People's Act is not maintainable against the petitioner. On the other hand, Mr. T. Ete, the additional public prosecutor, states that additional public prosecutor, in his usual fairness, have stated that section 166A is not applicable in the instant case. And neither section 134 applies. I have heard the parties at some length. It is noticed that the ingredients of 166A clearly shows that on a perusal of the ingredients, of section 166A clearly shows that it is only in respect of some investigation when a public servant disobeys any order which prohibits him from calling any person at any place or that he disobeys any other direction of law in conducting investigation or fails to record any information under section 151 or 154 of IPC, the said section will be attracted. The same is not the case here. Further, under section 134 of the RP Act, where it is provided that if any person, without showing any reasonable cause, fails in his official duty, the said section would be attracted. However, in the instant case, the petitioner had shown, it is prima facie noticed that the petitioner has shown a cause for not attending his duty much before the date of election. Full stop. Issue notice to respond number 2. Returnable within issue notice to respond number 2. Miss so-and-so appears. Miss so-and-so, the Wangmu, K Wangmu appears on behalf of the respond number 2. As such, no formal notice is required to be served. However, an extra copy you want, I think you don't have copy. However, an extra copy may be served upon the learned counsel. In the facts of in the facts narrated above, this court directs suspension of the proceeding, of the criminal proceeding against the petitioner in GR case number 9 of 2024, arising out of KLGPS case number 4 of 2024, till the next returnable date. Till the next returnable date. Listed after 2 weeks.
License. Record not required, madam. Record?
Records are required.
Yes, your lordship. Record may be called for your lordship.
Otherwise, in
Scan
every
copy.
case of Quashing,
Scan copy, madam.
Huh?
Scan copy, madam. So is to find out whether when his name was published and your lordship
and call for the scan copy of the trial court records. Bas, in between you insert that line, call for the scan copy of the
Obligation.
Yes, Mr. Majumdar's. Yes, sir.
I just indicate in the meantime my learned friend will come. Since I am conceding, madam, can be disposed of because we
You have to show me the act and the.
Madam, I'll show everything is annexed here. I'll show madam. Lordship may just see the facts first. Straightway, Lordship may go to page 36. I'll be very brief, madam. In short, I finish. Page 36, the first order passed by the.
This is Kebang's decision.
Kebang decision. It is a village authority. Now it is called customary court. So, Lordship,
But it is said in a number of cases they don't have jurisdiction. I'm yet to understand this Kebang part.
But what has happened? Kepa is still authorized to be a village court. Now it is called customary court. They can take a decision. Now earlier, this 2021 Civil Courts Act, which has been now enacted.
21 Civil Courts Act.
Madam, it is annexed here. I'll come to that. It is annexed here. Before it was enacted, the appeal used to be filed against that under the Regulation 47. Your Lordship is aware earlier there was a 1947 regulation.
That frontier regulation.
Yes.
I mean, appeal before Kebang.
Appeal, Kebang is the first court, trial court.
This is the customary first court.
Again,
appellate court.
No.
Achha.
Thereafter, appeal is to be filed before the deputy commissioner.
Achha. Okay.
Now what has happened? First decision, as your lordship will kindly see, I'll just cut it short, very brief and very simple. Page 36 is the first order. Lordship will kindly see final decision of the KEBA and dated 24th of May 2006. First sentence itself says, on dated 24/5/2006, in the KEBA office of DC, the disputed land between Sri so-and-so, Rupo and so-and-so, Jamo, regarding legging Monet area land has been decided. This is the decision.
Okay.
Now, next page, Lordship will kindly see. Last but one paragraph. After hearing the matter, all the present members in the KEBA has decided that the land should be divided equally. Simply, it was decided equally. My client is not satisfied with this. According to him, he is the owner of the entire land. He is the owner of the entire land.
Okay.
Now, against this objection at that time, because 2021 Act was not there, it is in 2006. So, our client filed an objection before the Deputy Commissioner. All these are on here. I am just verbally making it very clear.
He filed an appeal before the
Deputy Commissioner. Now, Deputy Commissioner did
under
not.
frontier regulation.
Yes. An objection remained pending for a pretty long time. In the meantime, 2021
Is
Act.
it an objection or appeal?
It was an objection. It can be presumed to be an appeal also, but it remained pending. Meanwhile, in 2021, the 2021 Civil Force Act has come into force. Now, this act says if the appeal or objection, whatever, filed against the decision of the KEBA is not decided or disposed of by the Deputy Commissioner within 1 year from the date this act comes into force, he will transfer it to the concerned court. It may be civil judge, civil junior division. It may be civil judge, senior division. It may be district judge also.
Within 1 year,
If we
from
cannot
the
dispose of,
date of
act comes into force.
from the date of act coming into force.
Yes.
Okay.
So, it was, since it was not decided, he sent it to the Deputy Commissioner.
He sent it to some other court.
He sent it to the district judge.
District judge.
District judge thought that considering the nature of the case and the value of the suit, he sent it to the civil judge junior division. Then civil judge junior division heard the appeal. That appeal your lordship will find at page 87.
So the civil judge heard.
And decided at page 87 lordship will find, and there is a judgment, and at the end of the judgment, lordship will find page 100 is the final order, property part of the order.
Yes. Page 100, yes. Yes. 100 he decided.
Decided and he dismissed the appeal.
Or he dismissed it.
Dismissed the appeal.
So it will be divided equally. Okay.
Yes, yes. Now, lordship, page 100 order, it is held that there has been no violation of the principle of natural justice. There is no infirmity in the KEBA decision, dated so and so. It is just and reasonable, and the same is upheld. The appeal stands dismissed. So, after dismissal of this appeal, we filed an appeal before the district judge.
Okay. Acha.
Which
Against
becomes,
his civil judge's order.
yes, because this is an appeal. Lordship can say page 87. It is civil appeal KEBA number 46 of 2020.
This is an appeal.
Appeal. Then
This
we
is
filed.
a civil appeal KEBA.
Yes. We
Yes.
filed an appeal before the district judge.
Again an appeal.
Again, an appeal. My learned friend raised a preliminary objection there, saying that no, this becomes a second appeal, and under section 15, subsection 3 of the 2021 Act, second appeal is not maintainable. Only first appeal is maintainable. That was decided, which your lordship will find as page 1119. 1199. Both the parties argued. My client's lawyer was very smart. He succeeded in convincing the court. My learned friend is smiling.
Okay.
That it is maintainable. So, page 119 it starts, page 124, it is held that page 124, my lord. Last paragraph. According to the objection of learned counsel for the respondent is turned down, and the case shall proceed before this court, treating it as an appeal.
No,
Under
in
section-
view of the paragraph before that,
Yeah.
I am of the opinion every order or judgment of civil judge exercising and so from shall lie to the court of additional district judge or district judge. So the district judge agreed that he can hear.
Yes. Then this was only on the maintainability. Then finally,
Hmm.
it was decided, next page, my lord, page 125.
Next page, yes.
Yes. 22/12/2023.
Yes.
So it was
This is by district judge.
district judge. It was heard, and at page 138 is the operative part.
Yes. In view of the above fact.
Yes. In view of the above fact, I do not find that the reception of the KEBA is totally conclusive to reject the claim of the appellant, but he may also succeed in the case subject to the proof of the facts, that is, that it is his land, or he may also totally lose the claim upon the suit land, but all those facts are subject to prove and disprove during evidence stage at the time of trial. As a result, the impugned order dated 5/6/2023 passed by learned court will be set aside and quashed with a direction to admit the appeal in terms of section 15 of APCC Amendment Act 2022 to go for de novo trial of the case.
Okay.
Appeal was entertained on merit. It was decided that it will go back for a de novo trial
Before the KEBA.
before the KEBA. Now, before the civil justice division, learned court.
For the
below.
civil justice, passed by the 5/6/23.
Yes.
Okay.
Now, against this, my learned friend has filed this revision petition. He has taken some grounds on merit, but primarily his ground is that the learned court of district judge erred in law in holding that the appeal is maintainable, because under section 15, second appeal is not maintainable. My lord, technically what I find is what my learned friend is saying is maybe correct. So if that is so, then against the first appellate order, since I do not have any remedy of second appeal, I have to come directly to this honorable court in revision. We both of us agree on that. My lord, let us not quarrel unnecessarily and take this time. So what will happen is, this order passed by the learned district judge will go, and I have to get an opportunity of challenging the civil judge junior division order directly before this honorable court in a revision. This is the simple thing. And just pointing out, your lordship wanted to know what is the law. My lordship, my learned friend.
Civil Courts Act.
Yes, my learned friend has annexed that, my lord, that your lordship will find at page 24.
24, yes.
Yes, first your lordship.
But when the incident happened, when the entire occurrence took place, that time this act, of course, was not there. But then that 1 year period they had given, right? That within 1 year, you have to...
That period has been given in this act.
In this act.
I'm coming to that, madam. Lordship will kindly see first page 24.
24 years.
Definition clause 2D. Customary court means court of traditional court or authority of a village indigenous to the state by whatever name called. So those KEBAs are now called customary court.
Customary court.
Now lordship may kindly turn to page 26. 26 at the bottom, section 15 is there, appeals. First one we can ignore, second one we can also ignore. Third page lordship will kindly see. Second also, yes. Appeals from decrees and orders passed by the Court of Civil Judge Senior Division in original suits and proceedings of civil nature shall, when such appeals are allowed by law, to lie to the district judge. So if the first appellate court civil judge had exercised his original jurisdiction, then appeal would lay. But here is a case, he exercised appellate jurisdiction. So no further appeal. So my remedy is to come under section 115 before this honorable court.
In a revision,
Yes. And that 1 year period I referred to, my lord, that is there in page 27, the second proviso under subsection 3, page 27, next page.
Provided that from
Provided
the
further that from the date of commencement of this act, in case an appeal is preferred against the judgment of customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or court of additional district judge may dispose of the same or proceed with the case de novo.
De novo.
And then one more provision. One more provision.
Where is that 1 year thing?
My lord, first proviso, I think, provided that any appeal on civil suits pending in the court of deputy commissioner shall be disposed of by the concerned deputy commissioner under the provisions of the Assam Frontier Regulation 1945 as expeditiously as possible, but not later than 1 year from the date of commencement. So since he could not, he sent it to the district judge sent it to the civil judge junior division, and she decided against the my remedy was to come before your lordship. I went before the district judge in second appeal. This is the thing. Well, my submission is let the matter go back. In fact, I have to be given an opportunity of filing a revision against the civil judge junior division before December. With that, your lordship may dispose of it. Given I?
No.
My learned friend has given a
List of this, lordship will have to pass an order. These last two orders will have to go, page 3. The 7/10/2023 order, by which, in fact, this is an order
You
where.
help me out, I'll pass the order. You both help me out so that I can pass the order.
lordship may pass a very short order, long order.
No, not
Very-
required.
because
Yes.
ultimately, nothing on merit.
Yeah, nothing on merit, nothing on merit. Normally, I've seen, I'm a newly appointed, I've seen, I give lengthy things, I'll have to shorten it. So,
Texts are otherwise longish, madam.
none, I'll not. I heard Mr. Swenson and Delip Majumdar, Mr. Swenson for the petition and Mr. D. Majumdar for the. Mr. Majumdar, you are for.
I'm for the respondent, man. My learned friend is for the petition.
Number 23.
23. Mr. Dicky Pangi is for the petitioner.
You are for respondent.
I'm for the
Sole respondent.
For
sole
respondent. There are two. Okay, petitioner and respondent.
Right.
It is stated at the bar that the
My,
petitioner.
my concession cannot be recorded like that otherwise.
Okay, fine.
Under-
I'll only.
Under the law, my lord.
Speak on the law front. It is stated at the bar that this application, this civil revision petition against the order dated 5/6/2023 passed by the learned civil judge senior division in civil appeal.
No, madam.
Passed by the district judgment.
Orders under challenge are 7/10/2023 and 22/12/2023.
Okay.
7/10/23 is marked with the final.
7/10 has to.
7/10/23 is marked with the final order of 22/12/23. Lordship may simply say that it is
22/12.
directed against 22/12/23.
No, that's not give us. 7/10, my lord, in fact, the learned district judge has come to a conclusion that the customary court is not a court. It will have to go. He has come to a conclusion that it is a tribunal. That is.
Okay, I'll reform it. It is seen from the records of the case, not, I mean, it is not stated at the bar choro. It is seen from the records of the case that on 24th May 2006, the customary court of the state of Arunachal Pradesh, which is called as the Kebang, passed the final decision of a dispute which was referred to it. The aggrieved party in the said judgment and in the said decision of the said decision filed a civil appeal before the Court of Civil Judge Senior Division?
No, madam.
No. After this, what happened?
No. After that, the
this,
respondent filed an objection
Before the
application
DC.
before the deputy commissioner. It was not even an appeal.
Acha, where is that?
My lord will kindly have the list of them.
No, where is it in the petition?
That is at page 34 or 40.
40.
40.
Yes.
This one I forgot to mark. Okay. Oh. The aggrieved party of the said decision.
Respondent, lordship may say respondent before lordship. We approached.
Okay. The aggrieved party respondent, the sole respondent, filed a case,
Objection
filed an objection
before the DC.
before the Deputy Commissioner East Siang District on 26/5/2026, 2006. In which, what did the Deputy Commissioner do?
He referred it to the district judge.
Where is that?
Page 58, I think, madam.
Page 58.
Mine.
This is the order by which,
Yes, appeal on which the learned district and session judge
Yes. Transferred it to
okay, he transferred the case
the district
to
judge.
to the district judge.
Right.
to the civil judge senior
Both the
division.
suits of raised has filed a related, say, the DC Pasigat has transmitted the related documents to this court for trial. Or inclined to take the representation as an appeal? No, he had taken up, filed a reply on the representation.
Yes.
Where is the effective order?
Yes,
DC's order?
this order is not before us, I don't have a copy. But from it appears that the objection file was taken cognizance by the district judge and subsequently transferred it to the civil judge senior division.
Yes.
So where is that subsequent transfer not annexed?
I think
No, that is not the next matter, that is not with me. But ultimately, the order was passed on 5/6/2023 at page 86 by the civil judge senior division.
86?
Yes.
86. This is the,
Yes, civil
May-
appeal.
no, this is civil judge senior division.
Yes.
What did the DC do?
this
DC,
is
my
sent
lord,
it to the district judge. District judge sent it to the civil judge unit division.
Civil judge senior division.
yes,
Okay. What did I say? The district judge, application filed before district commissioner.
the appeal.
Huh. No, not transfer the case. Not transfer the case. The DC, they transferred the case, right?
Yes, yes.
Yes.
To the district judge.
District judge.
To the district judge.
Deputy commissioner to district judge, district judge to
Civil
civil
judge
judge.
senior division.
So and so. And it was transferred to the district judge. Deputy commissioner's thing was transferred to the district judge as stated by the parties.
My lord.
Thereafter, the said case was transferred to civil judge senior division at Pasighat.
My lord.
And the case was registered at civil appeal Kebang. Civil appeal
Yes.
within bracket Kebang. Number 46 of 2022.
Which was dismissed on merit.
And the learned civil judge senior division,
Page 100, man.
page 100, right? And the learned court upheld the Kebang decision dated 24/5/2006. They upheld the Kebang
Yes,
decision
and
and
dismissed it.
rejected, yes,
The appeal.
and rejected the appeal.
Right.
Thereafter,
Respondent appeared before the, filed an appeal before the district judge.
one second, this is where, yes.
Yes.
Thereafter, the respondent filed an appeal. That is an appeal.
Yes, ma'am.
Yes,
Page
page
102.
107, ma'am.
102.
107, your lordship will file the provision. It is under section 15(2).
Then the, yes.
From page 102.
Then what did I say? It was transferred to
104.
appeal before the no, this 102 is an appeal before
The district judge,
civil judge senior division.
maybe. Madam,
See,
This is a decree in appeal.
Madam,
Oh, this is decree.
yes.
Then
Starts
the
from
Page,
104.
page 107.
104.
4 is the synopsis, 107 is the relevant.
Yes,
Yes.
yes.
An appeal was filed before the
District
district
judge.
and session judge,
Pasighat.
Pasighat, East Siang district,
Madam.
in which the, what was the order?
My lordship may say in which initially on 7/10/23 at page 119,
119.
the,
By, yes, by which
by which the
the court, by
And-
order dated 7/10/2023,
held that the appeal is maintainable. page 124.
124,
Right.
had held that every order or judgment of civil judge exercising as original jurisdiction or deciding any matter in appeal from village authority shall lie to the court of additional district judge or district judge as the case may be. Then what happened?
Then finally, page 125, the appeal was heard on merit and decided.
And that finally, by order dated 22/12/2023, the district judge
Disposed of the appeal at page
Disposed of?
138.
disposed of the appeal,
Directing de novo trial.
disposed of the appeal by quashing the order dated 5/6/2023, passed by the learned
Civil judge.
civil judge senior division,
My lord.
and ordered for de novo trial of the case.
My lord.
Against this was filed.
My lord, this revision.
Agreed by the said order. This is dated what? This is 12. By the said order, the instant application, that is civil revision petition 9 of 2024, is preferred before this court. Against the order Bulana, I've said, na? Against order dated 22/12/2023. It appears, it appears from the law in force during the time when the Kebang decision was given, that was what under frontier rules. What
Assam
was it?
Frontier Administration of Justice Regulation 1945.
Under that law, Assam Frontier Regulation Act of so and so.
1947.
45.
45.
45. I forgot, Mr. Majumdar, what you said under that.
Under provisions of section 15.
15,
Of
under
this-
section 15 of Assam Frontier Regulation.
No, Assam, Arunachal Pradesh Civil Codes Act
That will
2021.
come later. Before that, what was the position?
Opposition was that appeal is to be filed under the provisions of section 47 of the 45 regulation.
An appeal before the DC
Yes, ma'am.
from the Kebang decision,
My-
customary court.
From the Kabang, it is 46 to the Deputy Commissioner.
From the Kabang, it
Yes,
is to the
under
Deputy
the-
Commissioner.
Yes,
That is under Regulation 46.
regulation.
Under Regulation 46 of the Assam Frontier Regulation, an appeal lies before the Deputy Commissioner from the order of a customary court,
Customary. Village Authority.
village authority.
At that time, it was village authority.
Okay, a village authority. Thereafter, the code came into force.
This 2021 Act, madam.
Oh, you have annexed that. Where is that?
Page 24, madam.
Thereafter, the Arunachal Pradesh Civil Courts Act 2021 came into force
On 12/4/2021.
on 12/4/2021.
2020.
21.
Where is that? There's a reading.
At the top.
On
Was
the
published
date
on
of
12/4.
date of
12,
Gazette.
yes, gadget. 12/4/2021. And the said code provides,
in section 15.
and the said act provides more specifically under section 15, that appeals from the orders passed by the civil judge, senior division, in original suits and proceedings
Will lie to the district.
will lie before the district judge of that district. And in the proviso to section 3, it is provided that an appeal or suit pending before the district judge, if it is not disposed of within a 1 year from the date of coming into force of the act, provided further that from the commencement in the case of an appeal. No, you write that under the proviso to section 3 of the said act, it is provided that the deputy commissioner shall dispose of.
My lord, just I have to interrupt your lordship for a moment. The first proviso here says that it has to be disposed of within 1 year. Second proviso says about de novo trial. But second proviso was subsequently again amended and substituted, which your lordship will find my learned friend as annexed at page 13.
13.
That says that if you cannot dispose of within 1 year, you will transfer it to the district judge.
Oh,
This is how
that's
it
what
was.
I'm trying to find.
Page 30, madam.
13, that is a pleading.
3th number act 30, page 30.
30.
Amendment act.
Ah, yes.
At the bottom, lordship will find in second proviso, lordship has got my lord.
In second proviso.
In second
this
proviso,
one.
subsection 3, which this was there,
Yeah,
for
could
the
not
existing
dispose
entities, the
of.
following shall be disposed of. Provided further that in case deputy commissioner could not dispose of the pending in the court within 1 year from the date of commencement of the AP Civil Code Section 21, they shall transfer such pending appeal cases to the court of civil judge senior division, junior division, whatever it is.
That is okay. If he is not able to finish it within 1 year, then
You will transfer it.
the deputy commissioner shall transfer the pending appeal cases to the court of civil judge junior division.
Junior division, senior division, or district as the case.
Senior
may be.
division,
As the case.
as
may
the case may be,
be. And here it
under
was
the-
transferred to the civil judge.
as per the amendment to the
Second proviso.
second proviso of section
15, subsection 3. Subsection 3.
second proviso to subsection 3 to section 15.
My
3 to section 15 of the Arunachal Pradesh Courts Act,
2021.
Civil Courts Act, 2021. It is seen in the instant case that the appeal before the civil judge senior division,
No, appeal before the district judge was not disposed of. So it was
no,
sent.
it became second appeal, right?
Yes.
So, from the Kebang decision, it went to DC. From DC to civil judge senior division.
From there, we filed the appeal before the district judge, which became a second appeal.
From where you went to the district judge.
Yes, as a second appeal, which
In
is
the
not permissible.
case, it is seen that an appeal was first filed before the civil judge senior division, and thereafter an appeal was again filed before the district judge, which as such resulted in a second appeal in the instant case, which is not allowed as per law. As such, it is directed that the petitioner would file,
Respondent, madam.
or respondent would file the appeal, that is the aggrieved party, respondent, that is the aggrieved party, would file a revision. That is up to you.
Up to me. Lordship may simply say that
Why
I'll
not
have to
just set
challenge.
aside the impugn order, then give liberty to the respondent to approach the appropriate forum.
Yes.
Which is not according to law. Then you write, as such, it is seen the appeal, the revision filed before this court challenging the order dated
22/12/2023
passed by the district judge is not in accordance with law. As such, the order will have to be set aside, 22.
Yes, yes.
As such, the order dated 22/12,
2023.
22/12/2023,
Passed by the district.
not being in accordance with law, is set aside, and the petitioner and the respondent is given liberty to approach the appropriate court as per law.
Against the order dated 5/6/2023.
That is Kebang. No. That is
civil
the
First appeal.
first appeal.
Huh.
Civil judge.
5/6/2023 by civil judge senior division.
Acha, where is that?
Page 87, madam.
Liberty to challenge the order dated
5/6/2023.
5/6/2023
Passed by the civil.
passed by the civil Judge
Yes,
Senior
yes.
Division at Pasighat, Arunachal Pradesh, before the appropriate court of law.
Right.
Okay.
This petition is disposed of.
And only one submission, but under section 14 of the Limitation Act, this
No,
period spent on this
Will not
will
be.
will be excluded, ma'am.
That will be there in the, when the application, when the respondent.
Since it is noticed that there is substantial time, since it is noticed that substantial time has gone by, and as such, the limitation period, substantial time has gone by during the said process, the period will be excluded while counting the limitation period as provided under the Act.
For preferring the revision.
For preferring the appeal.
Revision.
Revision.
Respect,
For preferring.
respect, my lord,
Ah.
that should have been left to the appropriate court, my lord. That is always there.
My lord,
The
that is-
Limitation Act itself.
My lord,
Now, now this
Still,
amount,
you-
your lordship is
Huh.
condoning the delay already, my lord, before even it is filed.
my lord,
And it is always
That is
there.
already
If
there.
it is
My-
wrongly
my lord-
filed, that part.
Yes, that's what, that's what I'm saying.
my lord may simply say.
The respondent will file an appropriate application, whatever, my lord, before the appropriate court.
You know,
Is wanted to accuse person to make payment. Okay, where is additional?
So your lordship, further some more days may be granted for filing this additional affidavit since the petitioner was out of station, so I could not contact with him.
She wants to
lordship,
file.
time and again.
Your lordship, last opportunity may be given, granted.
On the prayer made by Ms. So-and-so, appearing for the petitioner, that she requires some more time to file the additional affidavit.
Additional
affidavit. In additional affidavit, the prayer is allowed. And she also prays that this will be the last opportunity, as she had taken time early on an earlier occasion to list this matter after 2 weeks.
Yes, your
I think given lordship, maybe 24th if my 24th. Yeah.
Let the list this matter on
24th.
24th.
Yes, ma'am. To after
24th, there are so many matters, huh? On 29th.
29, yes,
Yes, your
On
lordship.
29th of July 2025.
Yes, your lordship.
obliged.
Then again, Arunachal Civil Court Act
Yes,
What
madam.
happened? Affidavit in reply file.
Yes, madam. Pleading is completed, madam.
Okay.
Here, my lord, I am challenging Kava Corona, my lord, 6/5/2024, my lord.
You want to do the hearing today? Or some other day? There are other matters also.
Actually, I was.
You want to do it?
Yeah, my lord can fix it after vacation, my lord. Yes, next week he is not available, my lord. Otherwise, I was praying for disposal of the case, my lord. This interim is operating against me, my lord.
He has interim orders.
My lord. My lord, that this matter may come up after vacation, my lord, and then till then interim may be continued.
On the prayer made by both the councils, list the matter. On, give a date. We'll give you a date. 31st,
24, my lord.
24th again.
On
24th, there are so many matters. Do it on 31st.
okay.
31st of July, 31st of July 2025. It is also stated at the bar that the pleadings are complete and the matter is ready for hearing. Matter may be taken, matter may be disposed of. An endeavor should be made to dispose the matter on the next date.
Till then, my lord, interim order.
And then the interim passed earlier shall continue.
Obliged, madam.
Item number 9.
My lord, this is a criminal petition
Mm.
filed under 480 CRPC 973 in connection with Pasar PS case number 15/24 under section 66E 2000.
For what? For quashing of FIR?
Yes, my lord.
66 over
66, 66E IT Act. My lord, here in this case, the informant here the petitioner is a senior nursing.
1 second, Miss Rini, you are ready? You can represent both the parties and there is respondent number 3.
Respondent number 3.
Oh, you are there for respondent. Okay. Okay, let's see what is that.
My lord,
Let me go through the FIR.
But FIR in page number 26 of my petition. Written FIR.
26.
Page 26. Page 26 of my petition.
Wait.
Now we have to come
26, I'm not getting it.
page 26. 26.
Page 6. There is no proof.
Page 26.
Yes.
My lord, the FIR goes like this. To the officer in charge police station Basar, Leparada district, Contractual Pradesh, dated 18 April 2024. Subject FIR against one Srimati so and so, wife of so, presently serving as senior nursing officer at office of the district hospital, Likavali, under section 66E of IT Act 2000 for transmitting the private picture of the applicant and other appropriate provision of punitive law for continuously harassing and threatening. This is FIR content. Well, then what happened with your reference to the above cited subject? I would like to state that following words before your good office for kind perusal and further stringent action, please. That sir, the above named accused person has transmitted a nude picture of mine in a electronic media, and same has been received by my father, namely so and so, through his WhatsApp number so and so, from WhatsApp numbers so and so. It is pertinent to mention here that on the 16/6/2022, I have lodged an FIR against the above named person at Basar Police Station for threatening, virally transmitting my private picture, and the same was received by concerned.
He has already Lodged one before.
Yes, my lord. 2022, she lodged one FIR. And however,
it's
the
a-
said
let me-
FIR dated 16/22 was withdrawn at the instance of the
Wait,
undertaking.
go slow, go slow. I have lodged an FIR against the above named person and so and so for threatening me, okay?
Yes, my lord. Threatening me to virailing, transmitting by private picture, and the same was received by concerned IO on dated 7/9/20. That means FIR was received by 20.
But she,
However, the said FIR dated 16/6/22 was withdrawn at the instance of the undertaking that dated 09/09 to 22, written and submitted by the above accused person. That means here petitioner. A copy of FIR dated 06/09/22 along with undertaking dated 09/0/22 is enclosed here with for your ready reference. So, Lordship, this is the first FIR during 22, and thereafter subsequently what be it to hearing that the above accused person had undertaken that she will delete all the private picture of mine from her mobile phone and further undertake that she shall be liable if she transmit my picture in any social media, my lord, any social media or electronic media. However, even after such undertaking dated 09/0/22, the above named accused person is transmitting my private picture in electronic social media, which causing me a mental trauma, leading me to humiliation, and no electronic media or no social WhatsApp group has been mentioned clearly here in this FIR. Nothing is there. Lordship, now this was the incident of 22. Now, recently FIR was filed on 24. Then problem starts here. That my character, reputation, and image before my family, my friends, and other community have been heavily degraded by the conduct of the alleged accused person. My mental and physical condition is totally worsened by the conduct of the above accused person. It is further pertinent to mention here that the above accused person is continuously threatening me of dire consequences and thereby harassing me mentally. Now, now this 24 incident starts here in next para, page 27. It is worth to mention here that my father has received the aforesaid nude picture of mine from above named accused person while he was on his journey towards his election duty, and the same has caused a deep humiliation to him and thereby mentally disturbing him, leading to serious high pressure. Therefore, it is most respectfully prayed before your good office to kindly peruse the FIR and initiate appropriate action against above named accused person and book her under 66E of IT Act 2000 for transmitting the private picture of applicant and other applicants. Look, this is the, so now the crux of this FIR start from this page 27 last para. So here that in which social media, which WhatsApp group, it is not clearly mentioned. Yes.
But still, there are ingredients of 66. Let me see 66C of
Lordship. Now,
IT Act, Information Technology.
IT Act. Now look the page number this 35 of this IT Act.
Wait, let her take it out, or I can take it out from here. I can take it.
Page 35, my lord.
What is the section?
66E.
66.
66E. Punishment for violation of privacy. Lordship, punishment for privacy. 66 is violation of privacy. Whoever intentionally or knowingly capture, publish, or transmit the image of a private area of any person without his/her consent, under circumstances violating the privacy of that person, shall be punished with imprisonment. Which
so transmitting is enough.
Lordship, transmit. Now I'll come to that point. Now
transmit is defined.
I have not transmitted, and transmit was also done. There are circumstances that my lord, one thing, my husband was indulging with the government. They were extramarital affairs. Then I have to save my family. So this picture, how this picture was came. 22, they were indulged some extramarital affairs, complete informant with my husband. Then my husband have shot that screenshot of that informant, both. They have secretly deleted that photo, that photograph sent by my husband to me to get rid of out of my husband life. My husband sent me their photograph, this secret photograph.
The same photograph was an issue in the
That
earlier.
photograph was with me.
Yeah, same photograph.
Actually, in this case, my husband should be implicated, not me. This photo was captured by my husband and this informant. They have a consent relationship, both.
That can be that is a different fact. But the fact remains see, this is quashing of the FIR.
Yeah, Lordship.
I have to see whether ingredients are made out.
Lordship,
Transmitting is there writ large.
This uncontroverted, I accept that I have taken the photo, this nude photograph by my husband, because my husband has captured that photograph.
I think there are consideration is different, right? Settlement before charge sheet, settlement after charge sheet, settlement during trial. I think there is a judgment on this. There are different stages, right?
Yes.
Do you have that?
No, actually, at present, I don't have that.
There is a Supreme Court judgment on this. Because this is during trial. Now almost it's over.
Yes. Then try court.
Because there are all different considerations. Bail also during trial. Quashing also during trial. And at the late stage of trial, considerations are different.
Yes.
Because court has, the entire machinery has worked. Now you come for settlement.
Yes.
Get the judgment. I'll take it up tomorrow, day after, or Monday.
Maybe after 3 weeks, Your Lordship.
Monday.
No, my senior counsel is not a station at present.
You are there. Get the judgment.
I'm also going out of station towards some other district. Also, Your Lordship may call for the TCR also from the trial court. I think it will help in this support.
Not required. Your
Not required.
listing is there. 161 you have annexed, I think.
Yes, 161 I recognize.
Right. 161 are there, and I find 2. The PW1 deposition is also there. It's in the house victim. Right. Next week you cannot.
Next week, okay.
Then do it tomorrow.
Tomorrow I'm not prepared.
Today you are prepared, tomorrow you are not prepared.
Next week, it will be better next week.
Next week.
Yes,
Okay.
Your Lord.
And get that judgment.
Yes.
I don't have it. It's not written anywhere, but then there is. You also try. What are the consideration of settlement at different stages?
Yes, Your Lord.
As prayed for by the council. Leaves this matter next week. I'll give you a date, otherwise it will not come. On what? 2nd, Wednesday, 2nd of July.
Yes, sir. Much obliged.
Wait, please, my lord.
Bail hearing.
My lord. My lord, in this case, I have been under custody since last 118 days.
180 days.
118 days.
What is the offense?
Section 65(1), punishment for rape, 351(3), criminal intimidation, 4 and 6 of POCSO, my lord.
Oh.
Otherwise, my lord, in this case, bail was rejected on 29/5/2025 by the special judge, Alo. My only ground is that the requirement of the communication of the grounds of arrest, which ought to have been given to me as mandated under section 47 of the BNS as well as article 22(1) have complied with.
No grounds of arrest.
No, my lord. If my lord may have for a time being peruse page number 21.
So let me go to the FIR once.
FIR, my lord,
20.
we'll have page number 17.
20.
17 to 20. My lord.
Acha, 17 is the format.
Yes.
But do you want to? Okay. This is the arrest memo.
My lord,
Arrest memo as such are no grounds actually.
no grounds, my lord.
Similar case I had.
And on the last
Well,
occasion, my lord,
Lordship, in the arrest memo, if your Lordship see the arrest memo, your Lordship. On the previous occasion, when your Lordship has taken up that case, that your Lordship, your Lordship has stated that the reason and grounds are different. Your Lordship, we've come to page number 22, your Lordship. The ground shown is he is a named accused.
No, there cannot be a grounds of arrest, my lord.
On the earlier occasion, if your Lordship has seen,
There cannot be a grounds of arrest.
No, these are not grounds.
Grounds.
As it was stated in Pravir.
My lord.
Prevent accused from committing further offense, proper investigation, to prevent accused from causing disappearance, tampering. No, these are reasons of arrest, as it was differentiated. And what are no grounds of arrest were given?
No, my lord. If my lord may peruse the TCR, my lord, there's a remand order, page number 52.
52.
My lord, 52 of the trial court report, my lord.
She will have. And what about the rejection of
Rejection,
bail?
my lord, this issue was not raised before the London Special Court, my lord. It's been raised for the first time, my lord. TCR. Fifty-two is the first transit remand, my lord. Page number 52.
This is final, this is charge sheet.
That's LCR, TCR, my lord. Page number 52, if my lord may peruse.
Number?
52, my lord. 52, 52.
Yes.
That is the first transit remand which has been
Yes.
obtained from the executive magistrate. There's not even a whisper about the grounds of arrest or the reasons of arrest in the remand also. And subsequently, my lord, if my lord may peruse page
The
number.
remand order may not reflect the grounds
Right,
of arrest,
right.
but then I think the magistrate has to ask,
Yes, ma'am.
right?
Yes.
Whether the grounds of arrest were given.
Yes.
Your Lordship. Where are those? Those things are not there, right?
your Lordship, therefore I had requested Lordship on occasion to give a brief direction so that we can at least communicate, because these are the loopholes that unfortunately supports the accused person.
If my lord may peruse page number 11 of the TCR, that's the second subsequent remand order.
11.
11, my lord.
No, this is statement of the witness.
Please.
So what is it, Ginny? No grounds of arrest?
Yes,
Except what I have shown?
except for the fire, except for my submission would be that he is a named accused, your Lordship, only on that ground.
At least the basic facts has to be given.
That has to be given.
Why he is to be arrested. Now the
In
police have
fact,
come to know.
in fact, we have just communicated on the last occasion about the direction that your Lordship has given, your Lordship. And subsequently, the arrest memo has been accordingly made, your Lordship.
This has to be like,
yes.
Since my lord is aware of all these authorities, but still then if my lord wish to peruse, my lord. Yes, my lord.
Those things I have. That hit and run case judgment is not delivered, right?
Not delivered, your Lordship. We are still waiting.
This will be on, I think, what red-handed will be.
No, Vivian case deals with the regular IPC sections, your Lordship. Pursataya deals with UAPA issues. Your
Money
Lordship.
laundering.
Now the case which has been reserved by the Honorable Apex Court, it would be dealing with that ground of arrest would be similar in special acts and IPC or not. Should the ground of arrest be given, or should the ground of arrest been given directly or even after the arrest on the subsequent period, your Lordship, with an explanation? Those issues were
Good. Because the requirement is as soon as possible.
Yes, yes.
Not be at the time of arrest, but after that.
After that, if certain circumstances come to that provision also, the matter was heard and the judgment is reserved. I'll leave it to your lordship, otherwise on the same ground.
Okay, I'll pass it into chamber then. It's 4:30, yes. I'll see again, but then no grounds of arrest,
No
right?
grounds of arrest at all.
Rape case.
Yes, ma'am.
She's a minor, no.